Good morning. I declare open this public hearing of the Joint Standing Committee on Treaties. We're here today on the lands of the Ngunnawal and Ngambri people, and I pay my respect to Elders past, present and emerging. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. I ask all those present to just ensure their mobile phones are switched off or on silent. In accordance with the committee's resolution of 4 August 2022, this hearing will be recorded and broadcast on the Parliament's website, and transcripts of the proceedings will be published on the Parliament's website. Those here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. Transcripts of today's proceedings may not be available in time to meet the deadline for questions on notice. Therefore, could you please keep track of any questions on notice so that you're able to respond in the time required to ensure the committee can meet its reporting deadlines. This committee will now take evidence on the agreement between Australia and Japan concerning the facilitation of reciprocal access and cooperation between the Australian Defence Force and the Self-Defence Forces of Japan. I welcome representatives from the Law Council of Australia to give evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee?
Thank you, Chair. My name is Tass Liveris and I am the President of the Law Council of Australia.
And Leonie Campbell, Director of Policy at the Law Council of Australia.
And you have colleagues online?
We have 2 colleagues online.
Just invite them to introduce themselves.
Matthew Stubbs, member of the National Human Rights Committee of the Law Council.
And Stephen Carr, I'm also a member with Matthew of the National Human Rights Committee.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. The Law Council is the peak national body representing the legal profession in Australia. It thanks the committee for the opportunity to attend and provide evidence this morning. The purpose of the Reciprocal Access Agreement broadly is to facilitate cooperative activities between the Australian Defence Force and the Self-Defence Forces of Japan, for example, by allowing each nation's military personnel to train within the other's respective territory. The Law Council accepts that the negotiation of such arrangements has legitimate and important aims in terms of Australia's security, strategic outlook in the Asia-Pacific region, and the strength and efficacy of its multilateral and bilateral relationships. The Law Council has considered the Reciprocal Access Agreement specifically in the context of Australia's international human rights obligations in relation to the death penalty and its whole-of-government strategy to pursue global abolition of the death penalty. As the committee is aware, Japan maintains the death penalty, which publicly reported hangings as recently as July 2022. On this basis, the Law Council holds grave concerns that there is no explicit provision in the Reciprocal Access Agreement to prevent the imposition of the death penalty in situations where Japanese authorities have in custody or otherwise do not require the assistance of Australian authorities to arrest and successfully prosecute under Japan's criminal jurisdiction a member of the Australian Defence Force or its civilian component. In the exercise of Japan's jurisdiction where Japanese authorities do require Australian assistance, Australia is obliged under Article 21(5)(a) to assist in the arrest and handing over of a member of the Australian Defence Force or its civilian component, except in accordance with the annex relating to Article 21, where it considers that such assistance would be inconsistent with its international obligations. It is only in the record of discussion, which is of less than treaty status and therefore legally non-binding, that it is explicitly stated that this exception is intended to include situations where Australia considers there is a sufficient likelihood that the person could be subject to the death penalty. In this context, the Law Council is also concerned by the threshold of sufficient likelihood. The Law Council opposes the imposition of the death penalty in all circumstances for all people on the basis that it is fundamentally incompatible with the realisation or fulfilment of the right to life and the right not to be subjected to cruel, inhuman or degrading treatment or punishment. We again thank you for the opportunity to appear today and are happy to respond to any questions.
Are there any other members of the Law Council that would like to make a statement, or we're happy to proceed to questions?
No, thank you, Chair. We're happy to proceed to questions.
All right, thank you, Mr. Liveris. I'll start off and then we'll go around other committee members. So I guess at the outset, I mean, clearly we've had evidence at the beginning from the relevant departmental people that acknowledge that under this agreement there's a possibility. The term used in the previous hearing was vanishingly small. That was the evidence that we were given. But nevertheless, a possibility that a member of the ADF or the civilian component personnel could be subject to the death penalty in Japan. Your position is that any agreement that leaves open that possibility is incompatible with Australia's international obligations.
Yes, it is, Chair. And what we suggest that the committee ought do is recommend that binding treaty action in respect of the agreement be withheld until a written agreement is agreed to the effect that no member of the visiting force, including the civilian component, will be subject to the death penalty. This is a very narrow carve-out from the application of the domestic law of Japan onto the visiting force and the civilian component, and they are very easy words to insert. It is as simple as we see with other treaties of a like nature, as simple as a statement that says a sentence of death will not be carried out by either party. And the opportunity that the committee has is not to undertake a risk assessment as to the likelihood that a member of the visiting force may be placed in a situation where this occurs, but rather the opportunity to give primacy to Australia's statement on the abolition of the death penalty and comply with its plain language. And some of that bears repeating, including the statement of intent, which of course says Australia opposes the death penalty in all circumstances for all people, a broad bipartisan statement of 2008 which states that Australia is committed to pursuing this goal through all avenues available to us. This is one such avenue. It is further bears repeating that the basis of Australia's opposition to the death penalty, as stated on page 2 of the statement, says that it maintains that the abolition of the death penalty has broad bipartisan support. The international trend is strongly in favour of global abolition, and Australia will be a leader in efforts to end the use of the death penalty worldwide. Again, this is an opportunity for Australia to be a leader and reflect the broad whole-of-government approach that the strategy outlines, including at page 11, where it states that Australia may also discourage countries from using the death penalty by refusing to provide or placing conditions around the provision of information, assistance, goods or services in situations where the death penalty may be applied. And so we suggest that the opportunity here is for the committee to further the objectives of the strategy rather than diminish them.
I'm just interested in your...
Chair, yes. I wonder if I can just add to that in terms of your specific question. This is Stephen Kine. In terms of your specific question with regard to Australia's international obligations, the words of the second optional protocol to the ICCPR talks about opposing the death penalty and not allowing it to be exercised within Australia's jurisdiction. But what Australia is doing by this treaty is doing exactly that. It's saying that where it has, at this point before it signs the treaty, it has control to say you will not execute any Australian servicemen. What it is saying It's within its power at this moment. It's saying to Japan, you can execute any Australian serviceman, provided we don't have to get our hands dirty by handing them over or by arresting them. So it is in breach, we'd say, of Australia's obligations under the second optional protocol, because Australia is exercising its jurisdiction by saying to Japan, our hands are off. You can execute any Australian serviceman according to your law.
Well, that's an interesting point. I mean, look, I'll sort of ask one further question, then I'll go to the Deputy Chair. But I guess with respect to our international obligations, and it goes to the point that Mr. Kime was just making, I mean, under the ICPPR and the section optional protocol, that's generally understood as placing, ratifying countries under an obligation with respect to how they conduct themselves as an abolitionist state domestically, and as I understand it, wouldn't generally be understood as carrying over into the area where you're effectively talking about the criminal jurisdiction of another country, or doesn't carry specific obligations. Obviously, there is also the 2018 strategy that's come since then, and I think to some degree that the sensible reading of that is that it suggests that Australia will be taking an approach that goes further than just what we do within our own jurisdiction. But that strategy acknowledges, for instance, that there will be circumstances where we might consider providing assistance, even if a country intends to prosecute someone for an offence that carries the death penalty, provided they give us an assurance that either it won't be sought, or if it is sought, it won't be applied. So there's some sort of conditionality even with respect to the 2018 strategy. So I guess I just invite you to say something further about what you really believe is the international legal obligation on Australia, separate from what might be the worthy pursuit of every and all means to stand against the death penalty wherever it happens to be applied.
Chair, thank you. Can I suggest this? The international legal framework is recognised in the strategy and set out in broad terms on page 4. We take issue with the strategy being classified as qualified in any way. It is an absolute statement expressing Australia's opposition to the death penalty. And it really is a situation where we urge the committee to not take a near enough is good enough approach in respect of this issue, favouring the interests of completing the agreement and speed and efficiency in that respect, because the fact remains that we are sending members of our visiting force as part of their duties into a country that applies the death penalty, and so the issues are more complex than simply relying on and accepting an assurance. And again, I make my point, the opportunity is to strengthen the application of the strategy rather than be seen to and in fact be diminishing it. And as the strategy itself notes in its terms, there are a number of situations, and I refer to page 2, in addition to the broad statements of the basis for the opposition of the death penalty. It's pointed out that it's irrevocable, that miscarriages of justice cannot be rectified and no legal system is safe from error. So the reliance on discretion and effectively undertakings from international counterparts, we say, is misguided as well.
All right.
Chair, I wonder if I might just speak.
Yes, Mr. Stubbs.
Sorry, I apologise. I wondered if I might just speak to that question of jurisdiction under international law. I certainly endorse everything that Mr. Liveris has just said about the death penalty policy. In terms of the international law question, under the second optional protocol to the ICCPR, Australia is obliged to prevent the death penalty being carried out on persons within its jurisdiction. Now, as you very correctly point out, the traditional meaning of that is within its territory. But international human rights law now also accepts that there are instances where a state may have jurisdiction over an individual outside of its territory. To give you an example, some of the cases deal with, for example, if the British forces in Iraq had detained a person, that person was within their jurisdiction. The significance here and the way in which we might even distinguish the broader context with the one that's under consideration here is that Australia will be asserting jurisdiction over all of the members of the visiting force and at least some of the civilian component, because they will all be subject to the Defence Force Discipline Act when they're in Japan. They will all be, as members of the Defence Forces, subject to command. And so they are, in a very real sense, under Australia's jurisdiction in a way that an ordinary civilian happening to be in Japan might not be. So on that point, I think it's fairly clear that the international obligation applies. Chair, I wonder if I might also just briefly speak to two of the points that were raised in earlier discussion. The first was about the risk being vanishingly small. It is a little bit difficult to obtain official figures, but on our understanding from figures collected by the Japan Innocence and Death Penalty Information Centre and also by Amnesty International, there have been some 133 executions in Japan since 1993. That's 133 executions in the last 29 years. And there are currently 117 people on death row in Japan. So it is not the case that Japan does not carry out the death penalty very often. The death penalty is imposed frequently in Japan and is carried out frequently in Japan. And it's not the case that we need to envisage members of the Australian forces engaging in inappropriate conduct in Japan. We know that members of the Australian forces will conduct themselves in an exemplary way. But it is very easy for an individual to get caught up in the criminal justice system, to be wrongly accused, to be involved in a situation, perhaps a motor vehicle accident, where there might be different interpretations of individuals' intent in that context. So I don't think that it is correct to say that there is a vanishingly small risk here. It may be that it is not an enormous risk, but there should be no question here. If Australia is serious about its policy, then it needs to ensure that it doesn't enter into agreements that have any risk at all.
Perhaps a further point to make with respect to international obligations is that the Law Council endorses an approach which is consistent with international law and practice that recognises three levels of obligations with respect to human rights and their interpretation, and that is to respect, protect and to fulfil human rights. In this case, it's around the obligation to protect, which requires states to protect individuals and groups against human rights abuses, including, as Mr Stubbs has said, with respect to that extended jurisdiction in situations in which Australia has effective control.
Thank you. I'm going to go to the Deputy Chair.
Thanks, Chair. I have a couple of questions. Around the DFDA, whilst every member of the ADF falls under the DFDA, regardless of which nation you're in, it is different to civilian law and civilian charges. In regards to the death penalty in Japan, how many foreigners have been killed by the death penalty? And the person that you said that was hung this year, do you know their offence?
Deputy Chair, it is true that the recent executions in Japan have involved crimes of murder, homicide-related crimes, but it is also the case that the Penal Code of Japan prescribes the death penalty in relation to a much broader range of offences. And I urge the committee to not approach this question on the basis of a risk assessment, some sort of analysis of likelihood that a member of the visiting force or the civilian component may be executed or may commit a crime that exposes them to the death penalty. That is not the point. The point is, what will the committee do to uphold and give primacy to Australia's strategy, which is absolute in its terms, in opposing the death penalty for all the very good reasons that it articulates, and I urge against the near enough is good enough approach to favour other interests to this very important global issue, which Australia's statement says on page 2, why is abolition important? And it is this, that Australia's commitment to human rights is enduring, and as long as people face execution by a government, we will pursue abolition of the death penalty. And so that is the focus of the question, not so much what is the balance, what is the likelihood that someone might do something or might be exposed to something of this nature.
And thank you for your answer, but as a member of the committee, I want to explore all options. And whilst I respect your position and I don't disagree with it, I was just merely asking a question from your extensive research that you've clearly done. And so back to my question that you may not know, are you aware of any foreigners that have been executed in, say, recent times?
Look, I might take that question, Deputy Chair, and say that the most recent execution of a foreigner of which I'm aware occurred in 2019, so 3 years ago. That was a Chinese national. There were certainly executions of foreigners in 2009 as well before that. I'm not able to assist with your question about how many foreigners have been executed in a longer period, other than to say foreigners are relatively regularly executed under Japan's death penalty laws. There's no distinction, as I understand it, between foreigners and Japanese nationals in the carrying out of those laws.
Have you seen with any other treaty that's involved where something like this has been left in?
Mr. Deputy Chair, the similar reciprocal access agreements that we're aware of, importantly, all predate Australia's strategy. Some of them have included in them the basic sentence that I referred to earlier, for example, the Philippines Visiting Forces Agreement, which simply states at Article 11 that a sentence of death will not be carried out by either party. There are others that do have them and some that do not. But the importance I suggest that the committee might focus on and be interested in is that all of those agreements predate the strategy. And so the context in which the committee might approach this question now is different to what it was in the late 90s or thereabouts when the other agreements, or is in 2005 and other times when these agreements were negotiated and made.
And I appreciate that. And as a former soldier and a veteran, I don't want to see any of my people be put or even tried for anything that holds an execution outcome. So I want to be clear on that. But I will also explore, like I just did with those questions, all options. And other than that, Chair, back to you.
Thank you.
Deputy Chair, can I just add something to what my colleagues have said with regard to this? Of course, this decision is very important going forward. It does signal, if the treaty is put into effect in its present form, it signals to any other country with which we might want to have an agreement which carries the death penalty in its domestic law. It will signal that Australia will blink when it comes to negotiate these sorts of things, and that Australia isn't really serious about its bipartisan strategy with regard to abolition, and will allow the particular country that we're agreeing with to carry out the death penalty with regard to Australian soldiers. The other point I'd make, just with going back to questions with regard to the international obligations, the practical point to make with regard to this is that if a private citizen travels to Japan and is wrongly accused of a death penalty offence and is convicted thereof, they've made the choice to go there. We're talking about soldiers and civilians who have no choice but to go where they're posted by the Australian Defence Forces. So Australia is, in this particular case, very in a very realistic way, putting its citizens, its soldiers and the civilian component in the way of domestic law, which imposes the death penalty. So I think all of these factors are important for the committee to take into account in considering what it will recommend with regard to this treaty.
Thanks, Mr. Keim. I've got questions from Mr. Pike and then Senator Cox. I'm coming to you, Mr. Pike.
Thank you, Chair. I did have some other questions, but I'm just going to jump on that point while it's been made. The concern I have in the sense that we're putting people going there without choice. Wouldn't you say that any private citizen who's going to Japan, perhaps they've been sent there by their business or are engaging in some other way that they may not necessarily want to be in Japan, but they just happen to be sent there due to the course of their work or anything else? I see that as an equivalent. I don't really think that there would be defence personnel in Japan as well on other business that isn't related to this reciprocal access agreement. Wouldn't you think that this isn't actually shifting any level of risk that isn't already present for any Australian citizen, whether they be Defence Force personnel or anyone else who's going to Japan?
Mr. Pike, can I suggest it raises your question reinforces why Australia's strategy is absolute, but the difference practically between the examples that you gave is that one involves private interests and the other involves a government-to-government agreement. And the opportunity for the committee here is to indicate how the Australian government will give force to its own bipartisan agreement. That is to not only oppose the death penalty absolutely in all circumstances for all people, but to take proactive steps in relation to pursuing that goal globally. And that underlines the importance of the strategy, and it underlines the importance of the points that my colleague Mr. Keim made a moment ago.
Okay, let's take that point. If the goal globally is to try to eradicate the capital punishment across all jurisdictions, can you tell me how many? And I do apologise because I did catch the end of a conversation there, and I did have to duck out for a second there. How many times does Japan enforce the death penalty in recent years?
Mr. Pike, we have broadly the statistics.
In the interest of time, we just had that evidence given to us, Mr. Pike, that both the numbers in which it's been actually applied and those people still
Yes.
on death row. So I might just invite you to move to the next question because we're...
My next question was which country has the highest level of capital punishment?
Mr. Pike, can I suggest this? That we really do urge the committee undertaking some sort of statistical or risk-based analysis on this. That's actually a separate point to the question of how Australia will give effect to its strategy on the abolition of the death penalty. This is not a question of assessing risk, accepting something that's substandard and saying near enough is good enough because we have other aims that we wish to achieve and give primacy to above the strategy.
I think the answer to the question is China, the People's Republic of China, and I think that I think it's pretty clear that all the countries in the Asia Pacific, should be working together to ensure that liberal democracy is defended in our region, and I think that goes to the absolute crux of this agreement, and I think that. To suggest that a country that has a relatively minor number of capital punishments enforced compared to, I've got some Amnesty International statistics here, which has China down as thousands, and then it notes that China continues to execute and sentence to death thousands of people, but keeps figures secret. So I think that it's very much splitting hairs, in my view, to think that we would cast aside an access agreement on the very, very minor possibility that an ADF personnel may be subject to the death penalty in Japan, when the broader goal is to try to to sort of try to counterbalance the expansionist, Chinese regime, which is clearly threatening its neighbours.
Mr. Bowe, I'll take that as a comment rather than a question. I mean, only to note, obviously, it was the former government that was intent on signing an extradition treaty with China when all those concerns were raised, and we're lucky that we dodged that bullet, but not because that was the former government's view. I'll come to Senator Cox.
Thank you, Chair. It's been a question that has been raised previously in other hearings, and I just want to get on the record, the implications of the point of difference from other status of force agreements that Australia is a party to. The custody of persons pending the conclusion on judicial proceedings. What are the implications in relation to that?
Do you mean in terms of the requirement that a person be held in custody? Yes, the Penal Code of Japan provides that. If you bear with me a moment, I will find the reference. The Penal Code of Japan provides that.
I think the point in this one, though, is that, sorry to interrupt, is that it doesn't have a requirement to give sympathetic consideration to the request. So I know that within the Penal Code it exists, but giving specific sympathetic consideration to actually the request of the sending state in relation to the custody of a person has a pending judicial proceeding.
Yes.
Be kept in custody.
Two brief points. The Penal Code of Japan, Article 11, states that a person who has been sentenced to the death penalty shall be detained in jail until its execution. So that's what the Penal Code provides at Article 11.2. We recognise that the safeguards and entitlements that are provided for in Article 21 are very. That is at Part 8. The prompt and speedy trial and so on and so forth are significant. They are significant safeguards, there's no question, but that doesn't diminish our primary position, because to the extent that this relies on exercises of discretion and things of that sort, we suggest it's unsatisfactory.
Thank you. My final question is, this agreement has a requirement to protect the environment, cultural heritage and human health and safety. To what extent do you think these factors are protected, and what are the parameters around the protection, if you can provide commentary?
Madam Deputy Chair, I'm sorry, we have not looked at that. We are happy to take that question on notice if it is satisfactory.
That's fine. Happy to put it on notice.
Thank you.
Thanks, Senator Cox. All right, look, I guess I'll finish with one question. I mean, clearly we can see that the way in which this agreement was considered and negotiated took a long period of time, and on all the available evidence, it appears that this issue was one of the issues that required that duration of negotiation. And we were given evidence by the departmental and defence representatives to that effect, essentially saying that, what we've got here on the one hand is Australia's strong intent around being an active and model abolitionist state and in pursuing the end of the death penalty everywhere, and on the other hand, Japan's interest in maintaining its own sovereign criminal jurisdiction, and what we've got in this agreement is, as far as the signing of it indicates, the best compromise. But your position, just to bring it to an end, is that Australia should essentially, for these kinds of agreements, this one and any future agreement, unless we can obtain as part of that agreement a commitment from the other nation that no Australian citizen will be subject to the death penalty in any circumstances, that those agreements should not be signed.
Yes. We recognise that the agreement, the reciprocal access agreement and others like it, have legitimate and important aims. Clearly they do. But we cannot accept as a matter of principle and policy that those factors should outweigh the bipartisan and strong bipartisan commitment that Australia has made to in the strategy. And that is where the importance of Mr Kime's point is underlined, and it is if Australia sends messages to countries that maintain the death penalty that it will prefer other interests over its abolitionist stance, then that undermines and diminishes not only the strategy but Australia's approach as a leader in the global abolition of the death penalty.
Chair, if I might just add in respect of that question, there is some evidence, I believe, before the committee concerning domestic attitudes in Japan to the United States Status of Forces Agreement. And I think it's really important that we distinguish what's going on in that situation from what's going on here. The US SOFA dates from the 1960s, and it provides carve-outs from Japan's criminal jurisdiction in respect of US service personnel. That is a significant impost on Japanese territorial sovereignty. What is being proposed under this agreement is nothing of the sort. There's no question that Australian service personnel in Japan would be subject to Japanese law. The only question, and it's a small but important one, is whether Australian service personnel will be liable to be subject to the death penalty. It's not a showstopper. This is not like the Japan-US SOFA, where there are questions of excising Japanese criminal jurisdiction. The only point here is the carrying out of the death penalty in respect of Australian service personnel. So the ask is not a big one, and it's important to be clear about that.
Yeah, I take that point. I mean, the truth is that under this agreement, Australian serving personnel and civilian component forces, where they undertake or commit a potential offence that is a common offence between the jurisdictions, and they do so in the course of their official duties, will actually be dealt with under Australian criminal jurisdiction. So it does involve actually a carve-out of Japanese sovereignty up to a point. But I'll just go very quickly to Senator O'Neill, because we're running up against an important event.
I guess my question is, in this historical moment, as this conversation has been happening with Japan, and even as we're putting these words on the record, there is a very clear indication of Australia's will with regard to the death penalty that has been recorded at every stage of the negotiations. It is documented in statements attached to the treaty agreement that you've noted in your opening statements, although you articulated that it was of lesser significance. I also point to the comments by Senator Cox about, in her questioning, about the importance of certain parts of the conversation that have been had with regard to this matter and its sensitivity. And I ask, perhaps you might want to take this on notice, in the interests of democracy and accepting the sovereignty of partners with whom we have many, many shared values, is it fair to do, as you said, to completely remove ourselves from such an agreement on this one, albeit vitally important issue?
It's not a question of fairness. It's not a question of fairness. It's a question of what steps Australia will take.
Is it in the national interest, Mr. Liveris?
It's not a question of national interest in the way in which it's put either. The question is quite simply, what steps will Australia take to uphold the strong and absolute statements that are made in the strategy, and to what extent will it prefer and give primacy to other interests? That is the question. If Australia is seen to take a near enough is good enough approach to trade agreements and things of that kind, agreements like this, when it comes to the death penalty because it's too hard, then it will undermine the strength of Australia's commitment to playing a leading role in the global abolition of death penalty, which it has documented in a bipartisan fashion in the statement in 2008.
Thank you. Thanks, Chair.
Thank you. And thank you, all four of you. Thank you for your attendance here today. If you've been asked to provide any additional information, and I think there was something in the exchange with Senator Cox, would you please forward it to the Secretary within 7 working days. As stated in my opening remarks, it's the witness's responsibility to meet this deadline in a timely manner. You will be sent a copy of the transcript of your evidence when it becomes available and have the opportunity to request corrections to transcription errors. I now suspend this hearing until 11:40 a.m. for the Bali 20th Anniversary Commemorative Memorial Service. This hearing of the Joint Standing Committee on Treaties will now resume, and I welcome Dr. Mai Sato from Monash University Ilios Justice, the Capital Punishment Justice Project Crime Info and the Anti-Death Penalty Asia Network to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
My name is Mai Sato and I am Associate Professor and Director of Ilios Justice at the Faculty of Law, Monash University. I'm also here as Deputy Director of Crime Info, which is an NGO based in Japan working on criminal justice issues, including the death penalty.
Thank you. Although the committee doesn't require you to give evidence under oath, I advise you that this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you. I'd like to first note that 2 other organisations, Capital Punishment Justice Project and the Anti-Death Penalty Asia Network, were also part of the joint submission we made to this committee in March this year. Our position is that unless there is a clear blanket assurance that members of the Australian Defence Force will not face the death penalty in Japan, the Australian government should not enter into this agreement. I listened to the Law Council's presentation and they've discussed the issue of international law extensively, so I will keep my presentation on 2 points. First, on the 2018 DFAT strategy on the death penalty and on the Japanese death penalty. So on the 2018 strategy, this strategy really sets Australia apart from other countries that have abolished the death penalty because of its outward-looking policy of pursuing abolition globally. And it takes a principled stance against the death penalty, and I quote, "in all circumstances for all people." And a policy of this kind needs to be repeatedly reinforced and acted on for it to be truly effective. Other countries such as the UK, Norway, and the European Union also advocate global abolition, and they have published similar strategy papers to that of the Australian governments. For example, the UK has entered into an agreement concerning defence cooperation with Kenya in 2021. As you know, Kenya has the death penalty, but under this agreement, the UK government managed to maintain its principled stance against the death penalty, and the agreement states that if a UK military personnel is convicted of a capital offence, the sentence would be instead commuted to a prison sentence or a fine. And this is a clear example of the UK government abiding by its principled stance against the death penalty. And I'd like to note that the UK is currently negotiating a similar agreement with Japan. So for Australia to enter into this reciprocal access agreement would not only risk Australians being executed in Japan, but it actually undermines the sincerity of the government's anti-death penalty stance. It could create risks to the legitimacy of Australian and other anti-death penalty governments in the eyes of retentionist countries such as Japan and others. So I'll move on to my second point about the death penalty in Japan. I take the stance as a Japanese death penalty expert that it is not a remote hypothetical that Australians could be executed in Japan. And I'd like to quote some numbers, and I want to note that these numbers differ to the numbers given by the Law Council of Australia. The numbers that I'm about to quote are official statistics published by the Japanese government. So Japan retains the death penalty for 19 crimes. 98 prisoners have been executed by hanging since 2000. As of October 2022, 107 individuals are on death row who have exhausted or abandoned their avenues of appeal. and the UN Human Rights Committee have repeatedly raised concerns with the way in which the Japanese death penalty system operates, both under law and in practice. And I'm more than happy to elaborate on the Japanese death penalty system if there are any questions. And I will stop here. Thank you.
Thank you. I'll ask some questions and then we'll move around the committee. As you've stated, your position is similar to the Law Council in as much as your view is that unless there's a categorical assurance or commitment within the agreement that no Australian Defence Force or civilian component personnel could be subject to the death penalty, then the agreement shouldn't be entered into. You note that the agreement, the status of force agreement between the UK and Kenya. Australia has status of forces agreements with, I believe, the Philippines and PNG, where we've achieved that blanket or categorical removal of the possibility that someone would be subject to the death penalty. But we also have status of forces agreements with, I believe, Malaysia and Singapore, where that hasn't occurred. So, do you believe that whilst pursuing that blanket exemption is the sort of the highest ambition that would be consistent with the 2018 strategy? Do you believe that nothing but that is consistent with the 2018 strategy?
I'll use the example of the Malaysian example. I believe the agreement was signed in 1997, and I would differentiate between the agreement and the current agreement precisely because of the government's 2018 strategy. As of 2018, Australian government made a principled commitment against the death penalty. Therefore, under this agreement, I take the view that the government should not be entering into this reciprocal access agreement. And I am concerned that if entered into this agreement, it will jeopardize the negotiations between the UK and Japan's reciprocal access agreement. And if the Australian government's stance is that they want to promote global abolition, it is undermining that promise.
Okay. I just note, and this is quoted actually in the Law Council submission, that the Australia's strategy for abolition of the death penalty, the 2018 strategy that you refer to, it does contemplate circumstances where, while we would otherwise not provide assistance to a country in a law enforcement matter where the death penalty is in prospect, we might consider providing that assistance if we were given in that particular matter a reassurance that the death penalty wouldn't be sought, or if it was sought, it wouldn't be imposed. Doesn't that suggest that the strategy itself doesn't impose a blanket or a categorical impossibility of assistance? It actually leaves open the sort of case-by-case negotiation between Australia and a country that applies the death penalty that allows that country to give a reassurance, and having given that reassurance there, then allows Australia to provide law enforcement assistance or extradition.
I understand that the Australian government can refuse assistance where such assistance would be inconsistent with the country's international agreements, but this will carry very little weight if Japan already has custody of Australian self-defense forces civil component who have committed a capital crime. And I also note that in the record of discussion, it does talk about the possibility of refusing assistance will be assessed on a case-by-case basis. But it's entirely possible that in some cases the members of the Australian Defence Force could be executed even if there was some kind of implicit understanding that such case will not transpire. And I take the position that such a case-by-case approach is hard to enforce in circumstances where governments change over time, and the so-called goodwill trust that ensued at the time of the disagreement could dissipate it for some reason. So I think the reliance on this case-by-case approach directly undermines the 2018 strategy, and that it is not a remote hypothetical that an Australian military personnel could face the death penalty in Japan.
Okay, I'm going to go to Mr. Pike.
Thank you, Chair. I've just got one. made some comments to the previous witness, which I won't reiterate. But I just wanted to ask the question: given your expertise in Japanese capital punishment, how many of those was it 98 since the year 2000 have been foreign military personnel?
No foreign military personnel, but 9 who has been executed in history post-World War II. 9 foreigners have been executed in Japan, but those 9, they were not military personnel.
And I realise your expertise is in capital offences, but are there any cases where maybe you could provide us some advice on whether there have been cases where a serious criminal offence has occurred in Japan, or at least a foreign military personnel have been charged with a serious criminal offence, and how it's worked in practice in terms of treatment of those military personnel?
US military personnel has been prosecuted in Japan for serious offences, and I'm not going to be able to go by case what happened in these cases, but prosecution of foreign military personnel in Japan does occur, and especially with US military personnel.
Yes, I suppose that would make sense given the number of US personnel in Japan. What I'm trying to get at is I think I understand the theoretical concept and your argument, but from my perspective, it would seem that I think it would be highly unlikely that an Australian Defence Force personnel in Japan would find themselves in this situation. A criminal offence, let alone a capital offence. And I think if they did, that the reality of how it would work out would be that there would be such immense diplomatic pressure to avoid that, that it would be mitigated somewhat. So I'm intrigued as to whether we're having a lot of discussion around this. I'm just wondering whether it seems to me very, very small percentage in terms of likelihood that this would even occur. And if it did occur, that the practice would be that, it would be the Australian government would take all the necessary action to ensure that this person didn't face the death penalty. So I'm just interested in getting some comments on that. It seems that this is fine in theory, but I think in practice it would be such an outlier if this did occur.
I'd like to challenge the assumption that the possibility of an Australian military personnel getting convicted of a capital crime and executed is a very, very, very small possibility. The reason I say that is Japan executes every year. Japan has 19 capital offences, which actually shortfall of the definition of most serious crimes, which is understood as intentional killing under international law. I'm happy to provide the list of 19 offences, but just to give an overview, they include treason, arson, and illegal use of explosives, including instances where these acts do not result in death. And judicial practice is that the death penalty is applied for homicide cases, but there are other offences that doesn't result in death, which are capital offences in Japan. So, of course, we'd like to think that the possibility of an Australian military personnel committing a capital offence in Japan being executed is a small possibility, but in my view, it is a real possibility, and entering into the agreement with the knowledge that there is the possibility is problematic under the 2018 strategy.
Thanks, Chair. That's all from me.
Thanks, Mr. Poke. Dr. Sato, I guess I just invite you to reflect on a possible interpretation, which is that clearly in the case of this agreement, it's taken a long time to reach the point of signature. and we're led to understand that the 7 years or longer under which it was being contemplated, that relative delay was precisely because of this kind of issue, and there's been a lot of negotiation between the countries, and there's no doubt in the treaty itself and the associated documents that there's been considerable effort to deal with the issue, perhaps unsatisfactorily from your point of view, but to the extent that that's clearly been the intent of the government, the Australian government, and that the resulting agreement contemplates the risk of a death penalty prosecution and includes some safeguards that would mean that Australian defence personnel or civilian component personnel would be protected from that, and considering that there are other agreements that the Australian government is settling, which this committee is looking at, the Cloud Act agreement as it's referred to, which has some similar issues and some similar safeguards. Do you think it's possible to take an interpretation which says that the fact that Australia is making those efforts and working at length and painstakingly to secure the greatest possible protections short of a blanket exemption, do you think it's possible to interpret that as being consistent with the strategy and with Australia's sort of position as being not just an abolitionist state but a country that seeks to carry that stance and that principled view into its engagement with the negotiations with other countries?
I think the 2018 strategy is very clear on its very, very principled position against the death penalty. So what has been negotiated under this agreement would not stand up to the promise made. I understand that the negotiation has been going on for a long time, but I think this is the choice of the Australian government, whether they want to be seen as being the world leader in anti-death penalty advocacy. And by entering into this agreement, they are not standing by the 2018 agreement, and I'm concerned that it will undermine not just the Australian government, but other governments who had voiced their objections against the death penalty.
So I'll just take you back again, I mean, just on that particular view, because this is something that interests me with respect to text contained within that strategy. So it's that part that I read before. The death penalty affects our cooperation with foreign law enforcement agencies and our provision of police or other justice and security assistance in countries that retain the death penalty. For example, we cannot extradite an individual to a country where the offence concerned is punishable by death. An exception may apply when the foreign government requesting assistance gives a credible and reliable diplomatic assurance stating that the death penalty will not be imposed, or, if it is imposed, that it will not be carried out. So I guess what I'm putting to you is that that part of the strategy does not say there will be no assistance whatsoever with a country, extradition or other law enforcement assistance, with a country that practices the death penalty. What it says is there will be some circumstances where we may be prepared to contemplate, provided on a case-by-case basis, we're given a reassurance. And the reassurance is not just that the person won't be subject to the death penalty or that they won't be sentenced to death. The reassurance could take the form of, yes, they may be sentenced to death, but if they are sentenced to death, we will give you a reassurance that it won't be carried out. And there's some long-standing conversation in human rights, in the human rights field, about whether just the imposition or the sentence of a death penalty constitutes cruel and unusual punishment, even when there is a commitment that it won't be imposed. So I guess I'm interested in your view of that, because that is in the strategy, and that does not impose a categorical refusal to cooperate. It actually has, it provides an opportunity for the Australian government to cooperate where there is a case-by-case piece of reassurance. So, I mean, do you really hold to the position that the strategy requires nothing but the categorical guarantee that a death penalty can't be applied?
My reading of the strategy is that the Australian government categorically objects to the death penalty for all people under all circumstances. I think that is a quote from that strategy. So that is my interpretation, and that under this 2018 strategy, I think the agreement currently reached under the reciprocal access agreement is below the standard set under the 2018 strategy. In terms of extradition, I think that is covered by the second optional protocol without the 2018, without having to rely on the 2018 strategy. And there may have been goodwill on both governments. However, I'm concerned in practice that when governments change, that goodwill may not be carried forward.
Mr. Burrell?
Thank you, Dr. Sato. I'm just interested in the sort of getting to the heart of the motivation behind objecting to the signing of the treaty, and whether it's ideological or likelihood. And I suppose I'd like to challenge your challenge of my colleague, Mr. Pike, that about the likelihood. I mean, if we've had 98 executions since 2000, and that's 4.5 per year in a country of 125 million people, and then overlay the number of Australian Defence Force personnel that would be there, and the likelihood, I think we are talking about an extremely small likelihood that this would happen. So I suppose that goes to my point, is that do you think we should refrain from signing this because of the likelihood, or more an ideological objection to the death penalty? And if that were to hold, where does that put our treaties obligations or treaties that we sign with countries like the United States?
Japan's execution rates compared to other countries like Iran and China are significantly lower, but I'm not sure whether I'm comfortable in playing the numbers game in this, in the sense that we know from records that the Japanese government does sentence and execute on an annual basis. And yes, it may seem from those numbers that it is a very small possibility, but it is still a possibility, and it will be too late once the Australian military personnel or civilian component actually gets arrested for a capital offence, and then we will be looking back at this agreement with disappointment. So it's both a possibility and also an ideological objection based on the 2018 strategy.
Thank you.
Dr. Sato, you referred to the UK and the fact that, like as we did with the Philippines and the PNG, they secured a kind of a blanket removal of the prospect of the death penalty in relation to the agreement that they reached with Kenya. Do you know anything about the way in which the status of forces agreement that we understand is being negotiated between the UK and Japan is progressing? Is it your understanding that the UK will seek a similar blanket exemption?
I don't have any concrete information on the status of the agreement between Japan and UK, but my understanding of the similar agreements negotiated by the UK, like the example with UK and Kenya, is that UK will try to seek an assurance that a UK military personnel will not be subjected to the death penalty. And my view of Japanese government's position is that the Japanese government may try to use the current reciprocal access agreement between Australia and Japan as a template to negotiate with the UK government.
Well, that may be the case. I mean, to your knowledge, does the UK have any status of forces agreements with countries that does leave its personnel or civilian component personnel liable to the death penalty?
I don't have the information, so I take that on notice.
Okay. Are there other committee members who have questions? Either on the... I know we have Mr. Pike. Do we have anyone other than Mr. Pike on the telephone? No? Do you have anything else that you would like to add, Dr. Sato?
No, I don't. Thank you very much.
Thank you for your attendance here today. If you've been asked to provide any additional information, I think you've referred to a couple of things that you're prepared to give us by way of additional written evidence. Could you please forward that to the Secretary within 7 working days? As we always say at the beginning, it's the responsibility of witnesses to meet that deadline in a timely manner. You will be sent a copy of the transcript of your evidence when it becomes available, and have the opportunity then to request corrections to transcription errors Thank you for your attendance here today.
Thank you very much.
Suspend for a short period. Is this the next witness? I believe it is. All right.
You're right.
So we have Professor Rothwell. If you're happy to start now, we'll just move straight to you, if that's okay. I welcome Professor Donald Rothwell to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. My name is Donald Rothwell. I'm Professor of International Law at the ANU College of Law, Australian National University.
Thank you. Although the committee doesn't require you to give evidence under oath, I advise you this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence you give today will be recorded by Hansard and attracts parliamentary privilege. I invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, for the invitation to appear before the committee today. I wanted to start by briefly highlighting 3 points in these remarks. The first is the question of official languages. The agreement concludes as follows: done in duplicate at Canberra and Tokyo on this 6th day of January 2022 in the English and Japanese languages, both texts equally authentic. Now, this provision is not exceptional and is consistent with the 1969 Vienna Convention on the Law of Treaties. When there are two equally authentic versions of a treaty text in two different languages, there does, however, arise a possibility that different interpretations may occur between the two versions. The Vienna Convention rule in that instance is as follows: the terms of the treaty are presumed to have the same meaning in each authentic text. There remains a potential for disagreement between Australia and Japan over differences in interpretation of the English and Japanese language versions of the treaty, and this is particularly relevant with respect to aspects of the treaty that are unclear or ambiguous. Second point goes to treaty interpretation. A challenge associated with the interpretation of the agreement and its associated instruments is that they encompass 4 instruments with varying status. As a general proposition of treaty law, that is an unsatisfactory outcome for a freshly negotiated bilateral treaty and immediately causes and creates challenges for the parties in interpreting and implying the treaty, and for this committee in understanding the various component parts. This is especially relevant with respect to the interpretation of Article 21. With respect to the annex of the agreement, Article 29, Para 4 makes clear that the annex to this agreement shall form an integral part of this agreement. Article 2 of the Vienna Convention makes clear that a treaty may be embodied in a single instrument or in 2 or more related instruments, and whatever its particular designation. On the basis of that rule, it is clear that the annex is to be read alongside the main text of the agreement with respect to the interpretation of Article 21. The agreed minutes to the agreement are said to, and I quote, hereby reflect the following understanding which they have reached during the negotiation for the agreement. The agreed minutes are not part of the RAR and are to be distinguished from the annex. The agreed minutes do, however, fall within the ambit of the Article 32 Vienna Convention rule with respect to supplementary means of interpretation. The status of the record of discussion and its implications for the purposes of Article 21 is much more ambiguous. The record of discussion states, and I quote, it is not legally binding and does not alter the scope of the parties' domestic laws and regulations or international legal obligations arising under or existing independently of the agreement. Given the importance of the record of discussions with respect to the interpretation of Article 21, it is unclear why the interpretations recorded in the record of discussion are not reflected in the annex, especially given that the annex specifically relates to Article 21. Thirdly, Chair, I wanted to conclude with some factual scenarios. I see the following factual scenarios to be of particular interest to Australia and to this committee. The first is, where an off-duty Australian member of the VCFF commits a capital crime in Japan and is detained and prosecuted by Japanese authorities. The second is where an off-duty Australian member of the VCFF commits or is a person of interest with respect to a capital crime in Japan and returns to their base or barracks in Japan, and Japan requests Australia's assistance in criminal investigation. Thirdly, where an off-duty Australian member of the VCFF commits or is a person of interest with respect to a capital crime in Japan and has returned to Australia or is now serving elsewhere whilst on duty, and Japan requests Australia's assistance in a criminal investigation. I refer the committee to my detailed written submissions. Thank you, Chair.
Thank you, Professor. I'll go through a few of those things and then other committee members will jump in. I mean, the points that you raise about the fact that the treaty exists in the two language versions are interesting. Do you have a view on the reading of the treaty about what the sort of formal mechanisms for resolving any difference of view is?
Chair, in the normal course of events, any differences of view with respect to interpretation would be a matter between relevant government officials. There's some other interesting aspects of the treaty which I'm sure the committee is aware of, and that is the role of the joint committee. Not this joint committee, I should say, but the joint committee which is referred to in Article 27. It would probably play a role in terms of resolving any difference of views with respect to interpretation. And then there's a formal mechanism with respect to other disputes which could arise, which you'll find in Article 28 of the agreement.
Thank you. It's something we might have to pick up with the department. Coming to the various documents that are part of our understanding of the agreement, there was, I believe, that there was something in our original briefing, or perhaps it was in the evidence. I know that Senator O'Neill actually asked some good questions about this when we had the department before us. There was some suggestion that the minutes were legally part of the treaty or were legally enforceable. There was some sort of terminology like that. Your view, Professor Rothwell, is that the minutes are not in any way part of the treaty, and really they exist to be as a sort of something to which recourse could be had if there was a dispute about exactly what the treaty document and or the annex meant.
Broadly speaking, that's correct, Chair. It's important to note that the agreed minutes are formally published with the treaty, and they appear on the relevant websites, including the parliamentary website indicating the status of Australian treaties that have been negotiated in 2022. The agreed minutes, however, have a somewhat ambiguous status, but in my written submission and in the observations I've made today, I think there's probably an argument that could be advanced that, consistent with the Vienna Convention on the Law of Treaties, and in particular Article 32 of the Vienna Convention on the Law of Treaties, that the agreed minutes could be considered and could be relied upon as a supplementary means of interpretation to resolve any ambiguity that might exist with the main body of the treaty itself.
I'm just looking at the transcript of the hearing where we had the Defence and Departmental people, and Air Commodore Keane referred to the record of discussion as being the final element attached to the treaty package, and it's not a treaty-level document, but a recording of the parties' mutual understanding. So and I may be interpreting this incorrectly, but based on that, it seemed to suggest that the first three documents, the treaty itself, the annex, and the minutes, were regarded as being part of the treaty package and at treaty level, but the discussion document, the record of discussion, was not. But that's something I guess we can go back to.
Can I just ask a clarifying question?
Yes, Senator O'Neill, please do.
Could I just ask about the minutes where you said that Article 32 would see the minutes received in any dispute as a supplementary element that might assist with discussion to agree with interpretation. Is there any instance, Professor Rothwell, where minutes are regarded as one of those supplementary documents in accordance with Article 29(4), as you indicated in your opening statement?
I can't point to an immediate example, but what I can assist the committee with is the following. The first is that unambiguously the agreement, the reciprocal access agreement, as it's commonly referred to, is a treaty, and it's subject to the provisions of the Vienna Convention.
Which can be one document or a multi-document. So
that's correct.
Right.
And in that regard, if we turn then to the annex is specifically referred to in the RAA in Article 29, paragraph 4, when it says, the annex to this agreement shall form an integral part of this agreement. So I think that we can legitimately say that the annex is an integral part of the agreement and is to be read as the equivalent of a treaty instrument. We then move to the agreed minutes, where...
And because the minutes isn't mentioned in that section, Professor Rothwell, your argument then is it is of a different status.
Correct. And so there's a level of ambiguity about the agreed minutes, and agreed minutes, it needs to be observed, are not exceptional, but they're not necessarily something that one would ordinarily find released in a public document such as this.
But they have been.
They have been from time to time, and certainly in this case they have. I can certainly tell you that as a scholar with an interest in treaty law, it's rare to find agreed minutes such as this made publicly available for a freshly negotiated treaty.
Okay, how rare, and what would be the rationale in your view? Is it all right if I continue, Chair?
Yes, please.
So how rare, and in what would be the motivation for doing so with this particular treaty agreement?
It's rare in the sense that the agreed minutes are often kept at a confidential level between the states with respect to their negotiations. The reason why they would be released is that, as would appear to be in this instance, they assist in terms of providing an understanding of the interpretation of the relevant articles that are outlined in the agreed minutes. They obviously also assist this committee. They assist people like myself and others who've made submissions before the committee, and they provide presumably some level of reassurance about some of the questions that have arisen with respect to the head agreement. So it's unusual, but there may well be reasons why the agreed minutes in this instance have been released and made available.
So these documents, if I can put it to you, bring us together in terms of how we might advance our relationship with Japan. But whenever we encounter the other in whatever form, whether it's as country to country or person to person, obviously there are cultural differences and cultural practices. Clearly one of the significant cultural practices that is very, very different, that's been the topic of much discussion here, is the issue of the death penalty. Quite a bit of the minute taking that is now a matter of public record, it covers off on that issue, doesn't it?
Yes, and indeed it also needs to be acknowledged that these agreed minutes would only have been made part of this package that's before this committee with the consent of Japan.
Okay, so it's a public record, and in those instances you described the three scenarios of the off-duty Australian members either engaged in a capital offence or able to provide assistance while in Japan and able to provide assistance to inquiry into a capital offence out of Japan. If any of those situations were to arise, if I can go to your comment about the minutes not formally being part of the agreement, but definitely being able to be used now perhaps even more so as a public document, as a supplementary record of the discussion, which would then come into the public discussion and negotiations and any private negotiations at that juncture. Is that how that would work?
Yes, government officials would no doubt seek to rely upon the agreed minutes in the case of Australia to support an interpretation that they believed was agreed between the parties at the time of the conclusion of the instrument. So that's how it would work at a government-to-government level.
Sorry for the interruption, thank you. Do you think there's any ambiguity in the minutes about Australia's position with regard to the death penalty?
Let me just be clear here. We're talking about the agreed minutes.
Yes.
The difficulty I have with that is that if one carefully looks at the agreed minutes refer to Article 1, Articles 4 and 10, Article 17 and Article 23. The more significant document with respect to the death penalty is the record of discussion. And so it's the record of discussion which particularly goes to matters associated with the death penalty, and in my view the status of the record of discussion as a treaty level instrument is exceptionally ambiguous, and it's made very clear in the record of discussion that has been released before the committee by way of the national interest analysis that, and I quote, "the record of discussion is not legally binding and does not alter the scope of the parties' domestic laws and regulations or international legal obligations arising under or existing independently of the agreement." So I think a critical issue here is the difference in the legal status between the agreed minutes, which we've been discussing,
yes, and
the record of discussion.
That's actually really quite helpful for me in terms of, because that was one of the things I struggled with the department, was to really clearly get a sense of the status of the documents, and that is helpful. I've got another line of questioning when you're ready, Chair, to come back to. Thanks.
Sure, thank you. Well, perhaps, Professor Roth, we'll just go to the scenarios that you outlined. You outlined three scenarios, all involving a member of the visiting force, ADF or civilian component, in the other country, in the country of the receiving state, not undertaking some conduct not in the course of their official duties that could be regarded as a crime. In the first instance, detained and prosecuted. In the second instance, returns to base, but still within the receiving state. In the third instance, is back in Australia or in some other international jurisdiction. It seems to me, and I guess I'm interested in your analysis of it, it seems to me in the second two cases, in the second and third scenarios, Australia has effectively kind of reserved the right to not provide assistance if the ADF or civilian component person is being sought in relation to a crime that carries the death penalty or for which the death penalty could be imposed. In the first instance, that person would be in the custody of Japanese authorities. The Japanese authorities might additionally seek assistance. They might want access to the person's belongings, or they might want other information that would be within the capability of Australia to assist or not assist. and it would be Australia has reserved the right to not assist, but that might not prevent the prosecution from going forward. But it is the case under Article 21(4)(d) that where an authority has the primary right to exercise jurisdiction, it's indicated in the treaty that they shall give sympathetic consideration to a request from the other party. So that presumably in that case, Australia would make such a request. They would say, you've got a member of our personnel, they've committed a crime, and we are asking for you to return them to us so that they can be made criminally responsible under the laws and the rules of our jurisdiction. And whether or not the receiving state, whether it was Japan or Australia, went along with that would be a matter to how the countries regard and determine what constitutes sympathetic consideration. That's my sort of reading of it. Do you think that that's right?
Thank you, Chair, for walking through those various scenarios. And broadly, I agree with you in terms of your analysis. The difficulty is that there are multiple additional factual scenarios and elements that arise from that. Clearly, in the case of a member of the Australian visiting force or civilian component who is off base, is dressed in civilian clothing and commits a crime in Japan, which would be considered to be a capital offence, and is arrested and detained by Japanese authorities, you're right. Australia's position then is that it would be very much at arm's length from the ability to intervene. It would no doubt provide support to that member. And indeed, you're right, there may well be requests made to assist with the production of evidence, but we're dealing with so many different scenarios here, it's difficult to envisage. But in that case, if that was an offence that solely fell within Japanese criminal law, that individual would very much be within the exclusive jurisdiction of Japan. Australia doesn't, for example, make it a criminal offence for an Australian national to commit a murder in Japan. Australian law does not extend into those situations. There are other situations where Australian law applies to Australians' extraterritoriality, but it doesn't apply in that basic, simple situation of an Australian committing a criminal offence in Japan, even a member who's a visiting force member or part of the civilian component. The second and third scenarios that I referred to are ones in which Australia would be in a situation of either dealing with a request for mutual assistance consistent with the RAA or potentially a formal extradition request. And in those situations, you're right, there could be situations where Australia may or may not be in a position to assist. Australia might rightly, as you point out, seek to decline that request because there's a concern that the individual might eventually be charged with a capital offence. Once again, we deal with so many multiple scenarios here that there might be an assault that occurs in a Tokyo bar. The person who's been assaulted is unsure as to who the assailant was. The potential Australian Defence member or civilian member returns to base, perhaps even returns to Australia, and then criminal investigations commence at a later point in time where Australia might be called upon to assist. So it's really difficult here to, with any precision, pin down precise examples because the scenarios are just so wide-ranging. But in principle, I agree with the way in which you outlined and sketched the scenarios.
I mean, it comes down to, we've had evidence from Dr. Sato and from the Law Council. Their sort of view is that as a result of our position on the death penalty, and particularly as a result of the 2018 strategy, that Australia ought to be categorical with respect to these kinds of agreements. It was interesting at the end of the evidence of the Law Council. I think I'm right in saying that that one of those witnesses referred to, perhaps inadvertently, to a trade agreement. I mean, you could take an extension of our position and say we're not going to enter into any agreement with any nation that practices the death penalty. You know, that would be quite an extreme form of that position. We're going to use that leverage, every bit of leverage we've possibly got. We're not going to enter into any agreement, even if it's got nothing to do with criminal jurisdiction or criminal behaviour or anything. We're not going to enter into an agreement with you as long as you practice the death penalty. Now, I don't think anyone would say that that's what the 2018 strategy requires. The 2018 strategy clearly bears on this agreement because this is agreement that covers criminal jurisdiction and liability. And as people have put, it's quite different to talk about Australian tourists in the United States where the death penalty occurs, or in Japan where the death penalty can occur, and the circumstances of a member of the ADF or the civilian component, because they're going there as directed in the course of their duties. Mr. Pike raised an interesting question about people who are required to go as a matter of their employment, but I think that can be distinguished. But the approach of the Law Council and Dr. Sada, and perhaps yourself, Professor Rothwell, is that nothing less than a kind of categorical carving out of the possibility of the death penalty is acceptable, as opposed to where this agreement has got to, which is lots of effort, considerable effort to be made over a long period of time to emphasise our position as not just an abolitionist state, but as someone who wants to carry that view, that strong human rights position into all of our dealings and have influence on the world in that way. We've put that strongly, we've negotiated for it, and we've achieved some outcomes in the form of this agreement that seek to minimise the prospect that an Australian could face the death penalty. So I guess that's, I'm interested in your view. Are you in that absolutist position? What's your judgment of where we've landed with this agreement, and what, in your view, that the 2018 strategy suggests we ought to do?
Thank you, Chair. I should make it clear, I'm appearing today as an international lawyer, so my perspective is really to look at these instruments from an international legal perspective and to reflect upon Australia's international legal obligations. But in my written submissions before the committee, I remain very surprised that the record of discussion, which certainly would seek to go some way to provide the level of assurances that you've referred to, and I have no doubt that the Australian government sought to achieve those records of discussions in good faith, and the issues that we're discussing are ones that have been in the public domain with respect to the finalisation of this agreement for some time, and the Morrison government was well and truly aware of those issues. I remain therefore surprised that the record of discussion is not a treaty-level instrument and makes it very clear that it's not legally binding. I guess from my perspective, I'm surprised as to why some of the language that's in the record of discussion cannot be found in the agreed minutes, which would have been the obvious place where they could have been located, which, as I've already indicated to the committee, would have had a stronger legal basis than the record of discussion as it currently stands.
Well, look, I'll try and kind of put it more directly, and I take all those points. Even if those things that you just mentioned had occurred, it would still leave open the possibility of an Australian member of the Australian Defence Force being subject to the death penalty. Even it would have made the safeguards stronger, but it would still allow this circumstance where a person, an off-duty ADF or civilian component person, commits a capital crime, ends up in the criminal jurisdiction and custody of Japan. There's nothing in the treaty, even if it was taken at its strongest end of interpretive end, by virtue of having the record of discussion and the minutes upgraded to the kind of legal force that you describe, it doesn't rule out that possibility, does it? Or wouldn't?
I agree with you that there still remains, if you like, that sort of loophole under the types of scenarios that we've tried to point today.
And as a matter of international law, our international legal commitments don't prevent us from entering into this agreement. And they're not, this kind of agreement is not, as a matter of international law, inconsistent with the commitments we've made as an abolitionist state.
The position I would take on that is that Australia has agreed to certain commitments under international law with respect to Australian domestic law, with respect to the abolition of capital punishment under Australian law. Australia has also agreed to certain obligations that are reflected in extradition arrangements that we've referred to. This is not an extradition agreement. We're therefore moving beyond the realm of strict international law to what Australia's policy position is on these matters, which we've outlined. So, from a strict international law perspective, if Australia was to move forward to the conclusion of the RAA, I don't think that it could be argued that Australia is in breach of its international legal obligations.
Yes, I think that seems to be the case. I mean, because the 2018 strategy is itself, it's a clear statement of position, and it makes clear how Australia will approach this matter in certain ways, but it doesn't place us in itself under international legal obligations that could be determined in that way as to whether we were in breach or not. I mean, it's our own strategy in any case. Are there any other questions from committee members? I know we've got Mr. Pike was on the still. I don't know if Mr. Pike is still on the call. No. We'll return to you then, Senator O'Neill.
Thank you. Thank you for your expertise and your evidence today, Professor Rothwell. I just wanted to ask one more question about the interpretation with regard to the two language documents. I'm sure that you've seen cases where differences of opinion at that level have advanced. I'm new to this committee, and this is the first time we're sort of going through this process. Happily, I've been able to come to a couple of the ones on this particular matter. Again, those cultural differences, and I mean, this is the joy of having multiple languages. You know, we have, they allow us to reflect the cultural practices over many decades or centuries even. What quality of the interrogation of those documents would be undertaken to make sure that they are as close to a match for match, sentence, if we take a sentence as a unit of meaning, each one being a unit of meaning, how closely are they interrogated to bring them to as aligned as possible?
Thank you for that question, Senator. I'll respond as follows. Any United Nations level instrument negotiated under the auspices of the United Nations is, of course, concluded in the official languages of the United Nations. So there's a very high level of undertaking to ensure that the multiple language versions are identical. Nevertheless, international lawyers and occasionally international courts will get into debates as to whether the English language version is identical to the French language version on certain words. So I'm trying to illustrate the fact that differences of interpretation are matters that have gone before international courts and tribunals, and in some instances they've been quite significant. This, of course, is not a United Nations level instrument. It is, however, an instrument negotiated between very close partners who have long-standing relationships and long-standing practices in terms of negotiating instruments in English and Japanese. So I would have no doubt in ensuring that there's a very high level of compliance between the English language version and the Japanese language version. I'm not an expert in Japanese law, however, or Japanese language, and I've been unable to compare the relevant language versions and in particular look at the way in which a Japanese speaker and most importantly a Japanese government official might interpret the Japanese language version of the instrument with respect to some of these important points. The final point I will make, which I sort of alluded to, is that the record of discussion, which I've indicated in my answers to you, I place particular significance on, not only in terms of its legal status. There's nothing in the record of discussion which refers to the multiple language versions. The multiple language version provision that I referred to that's found in the Vienna Convention applies to the reciprocal access agreement and the agreed minutes and the annex. I don't think that's really in doubt. But there is an ambiguity, and it's unclear as to what the Japanese language version is of the record of discussion and what the status of that Japanese language version would be of the record of discussion. That's a matter that Australian government officials would be able to assist the committee with.
Thank you. Do you have any idea who would be the arbiter of that language difference should such a difference arise, in opinion of on an interpretation of a particular set of words?
Well, as I indicated, I think in a question that the Chair asked, there are mechanisms within the reciprocal access agreement for the resolution of these types of issues. So I referred to Article 27, which talks about the role of the Joint Committee that would be established under the RAA, so it could play a role. And then there's a formal mechanism under Article 28 of the RAA for dispute settlement. But normally these matters are ones that would be determined between relevant government officials. It could possibly reach ministerial level, but then there are these formal mechanisms that I'm referring to.
Okay. So you've made a number of recommendations at the end of your submission to us, your written submission to us, which essentially seek to overcome the problems you've described by reallocating some statements from supplementary documents, if I could put it that way, into the annex if possible, or up from the record discussion into the minutes to elevate their status. Okay. The final line of questioning that I have goes to a completely different matter that you raise in your submission, and that is with regard to the pilotage. Would you explain to me what your concerns are there? I've read it, but I'm not quite sure exactly what it would mean, in fact. So Australian warships would be subject to compulsory pilotage in Japanese waters is your summary statement in your concluding points. Japanese warships would not be subject to compulsory pilotage in certain Australian waters, especially the Torres Strait. Could you fill me in a little bit more on what that actually means and why you have concerns about that?
Thank you, Senator. And your summary of the position is entirely accurate. And all I was trying to point to the committee was that because under Australian law, sovereign immune foreign government vessels are not subject to compulsory pilotage through the Torres Strait. That's consistent with Australia's position and was well received by the international community. That position would remain under the reciprocal access agreement with respect to Japanese vessels that would also be coming to Australia for joint exercises and the like with the Royal Australian Navy and the Australian Defence Force. Australian vessels, on the other hand, navigating in Japanese waters where compulsory pilotage applies, would not be subject to that exemption. So all I'm trying to highlight is that there would be differential standards applied to Japanese naval vessels and Australian naval vessels in each other's waters because of the particular exception that exists in that setting.
And do you have any insight into why that exception would continue to stand, given this conversation's been going on for some years?
I really cannot assist the committee in that because I don't have any particular insight into those negotiations. Okay. All I can say is that the Australian position of adopting compulsory pilotage in the Torres Strait was a matter of great sensitivity for the United States and Singapore. Australia elected to make a concession on that point to make sure that sovereign immune vessels, such as foreign government naval vessels, were not subject to compulsory pilotage. That applies not only to Singaporean vessels, United States vessels, it applies to Chinese vessels that are passing through the Torres Strait. So Australia's practice is really entirely consistent in terms of how that is reflected in the language of this agreement. So there's no issue there. It's just that it's interesting to observe that Australian vessels would not be granted the same concession on my reading of the agreement if they were navigating through Japanese waters where compulsory pilotage applied, and I've pointed to some examples where compulsory pilotage does apply in Japanese waters.
Thank you. Thank you for your help. Thanks, Chair.
Professor Roth, I'll just come back to you on one point. Clearly, the treaty contemplates circumstances where Australia will be responsible for the conduct of its own personnel. And so if it's in the person's official duties, or if the offence is between two members, you know, a crime against the person, presumably an assault, or a property crime but committed by an Australian in relation to Australian property. So just going back to what you said before about extraterritoriality, there must be some basis on which an Australian who assaults another Australian in Japan can be charged with assault under Australian law.
That's correct, Chair. And I guess the scenarios that you're pointed to are ones in which we're talking about the events that occur within an Australian base or on an Australian ship, or between two Defence Force members, or between two civilian contractors who've agreed to be governed by certain laws and regulations. And the starting point there is that the Defence Force Discipline Act deals with military discipline and applies globally to those types of scenarios.
Even to civilians, because you mentioned, I mean, that, you know, we all understand that there are certain things in place to govern the conduct of members of the ADF, but this goes more broadly. So you could have a scenario where you've got a civilian member of the visiting force and they're doing something in their official duty. So they're driving from somewhere to somewhere else. And nevertheless, they commit a driving offence, reckless driving, causing property damage, or they might get into a contretemps with a citizen of Japan and assault that person. I mean, there must be some mechanism that allows that person, an Australian civilian, to be charged with a crime and dealt with under the Australian criminal jurisdiction.
You've now reached the limits of my knowledge, Chair. I cannot assist you in terms of answering that scenario, and I think that just highlights the multiple factual scenarios we're addressing.
Because presumably, I mean, even to the extent that where it talks about primary jurisdiction and the two sides giving sympathetic consideration to the desire of one side wanting that jurisdiction, presumably it would only be on the basis that they were going to hold their citizen properly liable. And if there wasn't the capacity to hold them properly liable, I don't know on what basis there would be for any sympathetic consideration.
Certainly, you're correct, Chair, in that my interpretation would be is that in the absence of an Australian law applying to a member of the civilian component whilst undertaking duties or activities in Japan, well, then that would create a legal vacuum in which Japanese law would be able to fill that situation.
Okay. Well, thank you for your attendance and your evidence here today. If you've been asked to provide any additional information, would you please forward it to the Secretary within 7 working days? As I said in my opening remarks, it's the responsibility of witnesses to meet this deadline in a timely manner. You'll be sent a copy of the transcript of your evidence when it becomes available and have the opportunity to request corrections to transcription errors. But thank you again for your evidence.
Thank you.
Committee, we will now suspend. This hearing will suspend until 2 p.m.
That was interesting.
We'll now resume this public hearing of the Joint Standing Committee on Treaties, and the committee will take evidence on the agreement between the Government of Australia and the Government of the United States of America on access to electronic data for the purpose of countering serious crime. I welcome representatives from the New South Wales Council for Civil Liberties to give evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee? I think you might be on mute.
How about about now, Chair? Can you hear us?
Yes, got you now.
Thank you. My name is Josh Pallas, and I am the President of the New South Wales Council for Civil Liberties.
And I'm Stephen Blanks. I'm an executive member of the Council.
Excellent. Thank you both. While the committee doesn't require you to give evidence under oath, I should advise you this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So I invite you to make a brief opening statement before we go to discussion.
Thank you, Chair. I'll deliver the opening statement. Can I start by acknowledging the traditional custodians of the land on which we are zooming to you from? That's the Gadigal of the Eora Nation, and I pay my respects to their elders past and present. I extend those respects to any First Nations people present today or listening online. Thank you for the invitation to give evidence on this important bill. We appreciate that all agreements such as this one are driven by a practical imperative, but we urge the committee to consider that practical imperatives cannot come at all costs. Australia already has a weak regulatory framework for the protection of privacy and a weaker one in respect of human rights. In our view, the further erosion contemplated by the implementation of this treaty go too far and must be remedied. Before implementation, there should at the very least be a comprehensive privacy assessment. Also, as a minimum, any implementation of this treaty should be subject to the same conditions that apply under the Telecommunications Interception Act, particularly by compelling the production of a comprehensive annual report. This law in and of itself, the Telecommunications Interception Act, is controversial for doing away with ordinary requirements that court supervise third-party access to information. The TIA hardly creates onerous conditions for law enforcement in the state and should be seen as establishing minimum standards only. Individuals must be given recourse to know about and challenge orders made under this treaty. And at the end of the day, our citizens shouldn't end up with less privacy rights and less human rights protection because of any implementation of this treaty. To move beyond the scope of the submission on one very minor point, serious crime is very broadly defined under the treaty. An offence attracting 3 years of custody is a very low threshold, which makes proportionality of this agreement all the more problematic. And finally, our in-principle support for the treaty and its implementation, subject to our recommendations, should not be taken to mean that we are generally supportive of the way in which the Commonwealth has expanded the ambit of terrorism offences and other crimes over the last couple of years. We're happy to take any questions, and thank you again for allowing us to give evidence.
Thank you. Well, I'll start with a couple of questions and we'll go around. I guess at the beginning, so you've talked about there's a number of things in the submission in any case, and you've mentioned the privacy concerns. You've made a comment in relation to reporting obligations, and then there are some matters in your submission around the lack of warning for service providers and their capacity to have time to really consider their response before they fall foul of the timeline requirements and related penalties, and a number of other matters. I mean, coming to the privacy, well, I guess both the privacy and the sort of the natural justice rights aspect. What's your view of this agreement as compared to the existing telecommunications interception arrangements that exist domestically on that front? I mean, law enforcement will say that it's in the nature of the investigations that they're undertaking that where they've got cause to go and want evidence in relation to a serious crime and that evidence is data or in the form of an interception, that the idea that they would bring their interest in that information to the person that they believe might have committed a crime would seriously compromise their ability to investigate the conduct in question. I'm interested in your response to that, but also your sense of how what applies domestically under the TIA varies from what would happen in that respect under this agreement with the United States.
Well, if I can answer that. The primary point that we make in the submission is that it should be the service provider who's given notice in advance, and giving the service provider notice in advance will provide an opportunity for the service provider to apply its own policies and perhaps make representations in relation to the proposed access order. I accept that it would not normally be appropriate for the individual who's the subject of the data to be given notice. That's not to say that appropriate authorities, privacy authorities, shouldn't be made aware of the access requests. And that we do say in the submission that there is a role for a public interest monitor or the privacy commissioner to be aware of orders for data provision under the agreement, and to be able to take appropriate action should they think that it's inappropriate or further work is required. Well, we have that system in New South Wales. In New South Wales, in relation to surveillance device warrants, there is a surveillance device commissioner or monitor, and his role is really to advise the police force and other agencies who are getting surveillance warrants on how to comply with appropriate standards having regard to rule of law interests in what they do. There is a need with this kind of regime to have that kind of oversight officer involved.
Okay, well, I mean, just to be clear on your evidence. So, I mean, you've got on page 7. On page 7.
Oh, I see. We do have that.
Yeah.
Yes.
So on page 7, you talk about the right for an individual to know of the existence of an order relating to them. So the suggestion there is that the moment that an order that would be transmitted through the designated authority to a provider in the United States, that the individual subject to the order would be notified. So that goes to that point I made before about the extent to which that compromises a law enforcement investigation or indeed an investigation by security agencies. And I think that's an issue. I mean, can
I take that on notice, and we'll provide a further solution on that.
All right.
So, and obviously there are other agreements of this kind internationally being entered into, and one of the things I'd like to do is have a look at how they handle that issue.
Yes, but with respect to the provider, I mean, yes, clearly the process is that the order is sought. It can only be forwarded by through the designated authority process, and the designated authority has to first receive this certificate of compliance, which would cover off, in Australia's case, it would cover off the warranting arrangements, so the approval by either the AAT or the security division of the AAT, depending on whether it comes from domestic law enforcement or from our security agencies. Why do you think, or what practical or probity reasons would there be for the provider who's then in receipt of that order to sort of know when the process has commenced? I mean, in some cases the process might commence and might not conclude. I mean, the AAT might not tick off on it, or the law enforcement agency might decide not to proceed with it. I'm just not quite clear on, with respect to your submission, why you think the service provider who ultimately has to produce the data or enable the interception needs to be sort of forewarned at an earlier time. And I mean, separately to that, I guess, would be the risk, and which really goes to the privacy question. I mean, it would mean, in that case, that rather than through the formal order process, a service provider is sort of alerted to the fact that someone whose data they're holding is being investigated, which puts them in a position of knowledge about that person that person would probably prefer they didn't have.
It may be that the best course is for the service provider to be told the kind of data, the nature of the data, without identifying the individual to whom it relates. The issue there, and the issue underlying that part of the submission, is the potential difficulty that service providers have in compliance with orders, and the cost to service providers of having to comply with orders. So that part of the submission comes more from the AIIA side. It's a joint submission with them. But my understanding is that is a concern of industry.
Yes. I mean, look, it's we're led to understand that the agreement covers the capacity to receive a contribution to the costs involved. I can't recall from the evidence we had from the department about exactly how that would work. Perhaps we just come back to the broad issue of accountability and oversight of the process, which you did raise in your opening. We would have been advised, and there were some questions in writing which has resulted in us being given some further evidence that there will be some sort of what you might describe as aggregate reporting requirements, so that as there is under the TIA at the moment, there will be, I think, provision to the Attorney General, and the Attorney General in turn possibly table something in Parliament that looks at the overall number and category of orders. You've talked about public interest monitoring. I just invite you to sort of flesh that out a bit further. So either public interest monitoring and/or reporting and oversight mechanisms that you think should be part of this.
So as to the reporting mechanisms, it's explicit in the TIA that certain reporting be done and tabled in Parliament within timeframes. And so the expectation would be, if there could be equivalence, that there would be in this explicit reporting requirements, including making the report public through tabling in Parliament. And that's not there at the moment, as I understand it. The as to the public interest monitoring suggestion, that there are a couple of different models in the different states. So I think Queensland and Victoria have officers called public interest monitors, and they have a range of responsibilities in to monitor warrants and so forth, which impact on privacy. In New South Wales, it's a more limited role. It's a surveillance devices warrant monitor with just with jurisdiction in relation to surveillance device warrants. There are a number of possible models which could be looked at for such an officer, but we think, and of course, on the federal level, there's the Privacy Commissioner and the Information Commissioner. A key necessity of giving a role to a monitor is to ensure they've got adequate funding to do it. And that is a problem with the Privacy Office in the Commonwealth at the moment, that there is insufficient funding to enable the role to be conducted fully and properly. Whilst I could understand there might be hesitancy about creating a proliferation of, officers with monitoring roles. Could be done within the Ombudsman's office or the Privacy Information Commissioner's office, if there's a option to having a separate monitor.
And just if I might add to that, I think in some respects there is a utility in having the monitor situated either within the OAIC or the Ombudsman's office from a sort of whole of government oversight approach, so that there's sort of some continuity and almost some way in which that whoever is monitoring and whoever has oversight over this regime is able to, do that in a way which is proportionate with the way that they monitor and operate in other aspects, but also so that they can report to government about holistic issues around, for example, things like privacy and data, if it was vested in the OAIC, for example.
Yes. I think I'm right in saying that there is some reporting, particularly, I assume, in relation to sort of security agency initiated orders applied domestically under the TIA. There is some reporting through the Parliamentary Joint Standing Committee on Intelligence and Security. Has your organisation ever come to know about circumstances where an order has been provided and data is collected or interceptions occurred in relation to a person where ultimately they weren't found guilty of whatever they were suspected of doing, but that they suffered other kinds of harm as a result of having their data collected or their communications intercepted, then they have sought to be compensated for that, or to have that the wrongfulness of the order determined? Does that ever come to your notice?
Certainly done cases involving wrongful disclosure of personal information by government agencies where the Privacy Commissioner has ordered compensation to be paid, and the particular circumstances, involved personal safety of the complainant when information was given to an ex-partner, which placed the complainant at significant jeopardy. That's a slightly different situation, but wrongful release of data can be very damaging. The Optus case recently is an example of that. And the consequences for individuals of wrongfulness can be significant.
Yes. I mean, you would think, obviously, it's possible for any part of the law enforcement and justice process for things to go wrong, and sometimes for decisions to be made and investigations to occur in a way that's not correct and that does harm. And there needs to be mechanisms for private citizens to have those circumstances inquired into, and for them to receive some sort of justice or compensation if that's been the case. I'm just interested in whether you've got any knowledge of that happening, because the referent for us at this stage would be where that occurs because of orders given under the TIA in the sort of domestic access scenario. But with this one, we know that this agreement puts obligations on both sides with respect to targeting and minimisation. The question then just becomes whether someone who is adversely affected through that done poorly has the ability to get that reviewed and to be compensated if that's relevant.
Yes. So another sort of common scenario is a officer of an agency seeking personal information of an ex-partner of the officer or the ex-partner of a friend of the officer. And
But what you're describing there is would be corrupt and improper conduct.
correct, but one would never find it. I can't think of any instances where complaints have been made to the Privacy Commissioner about that, because the ability to find out that it's happened isn't, in relation to data, isn't there. In relation to personal information, the victim often does become aware and can make a complaint, and there are many, many such cases, far too many. But there is a risk in this regime, it's an inherent risk in this regime, where you don't have court supervision of the provision of data, that requests, improper requests, corrupt and improper requests could be made and not detected.
And I guess what you're suggesting is that at some point in the process, anyone whose data or communications are the subject of an order ought to be notified. I mean, obviously, if the process happened as it should and it was in relation to a serious crime and there was a solid basis for making an investigation, in many instances it's going to result in a charge and a prosecution and perhaps a conviction. But what you're suggesting is that in some cases an order might be granted and data might be received or an interception might occur, and if it didn't proceed to anything formal through the justice process, the person who'd been the subject of the order would never be the wiser, and you're suggesting that at some point they should be the wiser.
I think that's right. That is right. And if the data isn't used for a prosecution, I think that's right, and that would be a useful safeguard mechanism. But after a period of time, and the period would have to be specified, if a prosecution doesn't result, then there be notification.
Okay. Other committee members? Mr. Birrell, jump in.
Mr. Wilson, just add to your phrasing of the scenario is that at some point they should be notified. At what point? And if they were notified at a point in which a prosecution for an existing investigation is happening, that the notification might threaten ongoing investigations into other aspects surrounding whatever they were investigating in the first place.
Sorry, Mr. Birrell and the Chair, but respectfully, if you put a time frame on this, the issue that could arise is where you've got a long-term investigation going on between the two countries. If that time lapse occurs, then all of a sudden we've got a notification that triggers, which then potentially puts these interactions in the cyberspace. They go to ground, and then we've got to start from day zero again. So putting a limitation like that, I would say, potentially compromises our ability to be effective when it comes to trying to protect our borders from cybersecurity threats.
I think both of those comments are well made, and certainly, Mr. Birrell, we were talking about the fact that some have suggested that at the moment someone seeks an order in relation to a person, that person ought to be told. But I think clearly that would interfere with the ability to conduct investigations. But the example which I think puts it at its most sympathetic is where law enforcement or security agencies for some reason think that there's a basis for looking at something, the conduct of a particular person, and they seek data or an interception on that basis. And then the investigation concludes, and it turns out, even in the judgment of the law enforcement agency or the security agency, that they were wrong. But despite having a good reason for wanting to have a look at the person's conduct and related data, they themselves conclude that this person didn't do anything wrong and that they somehow got the wrong impression through other evidence. The question then becomes, does that person get told?
Can I just ask a clarifying question? Is it more around the judicial processes of the two countries that exist in relation to the definition of serious crime? Because when you are, essentially, let's put it in the framing of law enforcement agencies, you're trying to build a prima facie case in relation to whether an offence has been committed or not. And in order to do that, there may be a time lag in between the two countries in relation to investigation. And given the definition, the broad definition of serious crime, both in the US but also in Australia, they could not or may not marry up. Would that be correct in saying, in your terms? But it's also a case of like not putting a time frame around that, but also understanding what serious crime constitutes within both countries and what it is it's actually trying to be determined, and looking at that from an evidentiary point of view of what actually are the elements of each offence that is being committed. So
yeah, I mean, I think here, we'll come back to you, and sorry, I apologise for our little internal conversation here, but obviously that serious crime is defined as being an offence that carries a sentence of 3 years or more. And so presumably here, either a law enforcement agency or a security agency needs to be seeking information in relation to conduct that could constitute a crime of that nature. They then need to, in order to get the order, they have to go off to the AAT, either the AAT in itself or the security division in the case of an order that is sought by ASIO, and have that ticked off before going through the designated authority that would then go and seek the information from a US provider. So that would be the process at this end.
And just to clarify your point, that, and I'll lend on my policing career in this, because that's an individual case, but there's also operations that encompass many stings or operations within those that are captive of cyber and organised crime activity. It is useful then to let that time lapse in relation to constituting a significant serious crime, and not trying to do that with the individual that possibly is not the person who's actually instigating it from a more high level, is probably an easier way to put that, but also that there may be syndicates that operate in order to do this. So I hear what you're saying about the definition of a serious crime being 3 years, but it's also from an operational point of view and from a tactical point of view, police forces across the world use this in order to understand criminal and organised crime behaviour, to be able to elicit that and to break syndicates in that way. So I think the definitional aspect of what constitutes a crime, a serious crime in one country, may not essentially allow that to be the same and the same time frame to allow them to net more than one offender in relation to that.
All right, look, that's interesting from our point of view, and you've had the benefit of hearing that. So I invite you, if you've got anything that you think goes to those issues, particularly, I guess, the timing aspect of it, we're happy to hear them.
Chair, can I just touch on that serious crime point again? So I think in relation to the notification of individuals who, to whom orders have been made under the treaty, I think we would feel much more comfortable with the regime if the threshold for serious crime was clearly higher. Now, I appreciate what Senator Cox is saying around the difficulties of operations where you're engaging with matters of organised crime or joint criminal enterprises or, terrorism, bribery, treason, complex corporate crime. Appreciate that those investigations take quite a long time. But there are a whole raft of offences for which an individual could be incarcerated for 3 years, which are just simply matters of personal violence, driving offences, minor drug offences, the ambit of orders that can be sought. Now, whether the extent to which intelligence agencies and policing agencies to be willing to expend resources and seek these orders is sort of another question. But even the theoretical existence of these orders being able to be sought in relation to crimes which are quite minor means that we have a relatively high bar for what we think is proportionate. And I think that's like, we're somewhat torn in relation to this as well, in the sense that, in our view, the Telecommunications Interception Act already removes a whole heap of protections for civil liberty. But we're pragmatic in the sense that we know that the TIA does set some minimum standards that this treaty doesn't, and that it would be a good bar. And we are conscious of the threat of organised crime, terrorism, bribery, corporate crime. And there is going to be some middle path there. But we're just not sure that the settings as they are fall in the right place when 3 years of imprisonment is what is called a serious crime.
Yes, well...
Can I ask a question? Sorry, Chair.
Yes, no, please.
If you were to use a more simple example then, like something like freedom of speech, in relation to what's suggested in this agreement around the introducing or supporting US-level freedom of speech, which is something that we in Australia have worked really hard to eliminate, particularly the destructive nature of it. How would you see that might have impact in this agreement? So if we were using that as an example.
So you're asking, Senator, about speech that is considered harmful and unlawful in Australia, but
within this agreement's context, we're asking to support or even include the US level of freedom of speech in relation to it.
Well, I think what the US has made it clear to us that to the extent that we were issuing orders in relation to crimes that would be committed by way of speech, the US would reserve the right to not assist because of their position on freedom of speech.
Right,
whereas we reserve the same right, or an equivalent right, with respect to crimes that could attract the death penalty. I might have that wrong. Some people are raising their eyebrows at me.
My understanding is that
that's true.
In the agreement, we actually wouldn't, that we're looking to introduce the same level of freedom of speech where there's been a crime that's been committed. So, for instance, a hate speech, which essentially could be determined as a serious crime in Australia, but not necessarily in the US. So if we were to, within this agreement, then include that as, and I know it's happened in the past where we've stopped people travelling here from the US or Canada in order to provide forums of hate speeches, essentially. And that freedom of speech aspect being included in an agreement like this, how quickly would we see the impact, or would we be able, how severe would the impact be in relation to it being defined as serious crime, would be my question to the witness.
Thank you, Senator Cox. I think the Chair has the characterisation of the agreement right, as we understand it. But we are strongly sort of of the view that in order to prevent as much as possible the transposition of American-style free speech in Australia, that protection should be enshrined within the agreement and not left to sort of understandings between governments through sort of side letters or through law enforcement agencies. So we should absolutely be able to reserve our right in relation to what we can transfer to them. We should absolutely be able to reserve our right with respect to the death penalty. But as far as possible, I think we would want to be able to have access to information around hate speech and all of that. And whether or not that's a practical suggestion, given the negotiations that have to go on between governments, is sort of another question. But obviously, as an organisation, we're quite strongly supportive of protecting against hate speech and sexual harassment and LGBTQI discrimination or those sorts of things.
Yeah, that's fine. Thank you.
Senator O'Neill,
Thank you
please.
very much. Thank you for your submission and for your evidence today. I just want to take you to your submission with regard to burden on service providers. You make the case there that there's a disproportionately heavy burden on receipt of an order for service providers. I guess my question is, just as a citizen of the country, if you have the benefit of being a service provider, shouldn't you accept your corporate responsibility to make sure that information that's moving through your vessel isn't going to compromise the well-being of others? I don't see it as outside the realms of doing business for these entities.
Yep, that's a fair point. As I think I said earlier, this is a joint commission with one of the industry associations, and I think the content of that part of the submission reflects the industry view. Civil liberties organisation, we don't necessarily have a particular view on business interests.
Right.
But it's a joint submission. The power of a joint submission is that there is a level of agreement between industry and civil society on the content. I think the extent of the burden placed on industry for compliance needs to be taken into account in any regulatory regime.
Yeah. I guess the thing is, if you stand up a business, though, you do have to have issues. You do have to manage the security concerns of the users of that business. I'm concerned from looking, overseeing financial institutions where there's a sort of a rejection of a need to make sure back office in terms of management of information is properly looked after, and that matters are complied with, because it's not in the interest of shareholders. So I'm seeking the interest of citizens to make sure that their service providers actually do the right thing, and that is a cost of doing business is what I'd put to you. But I acknowledge that you're not primarily responsible for that in your submission. Could I just take you to a couple of other issues? The agreement's due to be reviewed within the first 12 months, as I understand it, and then periodically reviewed following the first review. Do you think that that's going to be sufficient to reveal any of the concerns that you've raised in your submission, if the matter goes ahead without change?
Yeah, sorry. That depends on whether or not there's publication of data about how this agreement operates when it's enforced. So, if there is data published similar to the data that is related to the operation of the CIA, then you can have a more sensible review of it. But if there is no data, you have a sensible review.
Okay. The annual reports that are referred to, provided by each party to the other, do you have a view about the usefulness of that?
I don't think there's sufficient information about what the content of the annual reports is going to be. And I don't think it's clear that the annual reports are going to be publicly released.
Okay. All right. So that's helpful. One of the issues I think that's embedded in here is the concern about formal dispute mechanisms provided, dispute resolution for the mechanism within the agreement. Do you have a view about what an appropriate dispute resolution mechanism might look like?
That's
And good question.
Very good question.
Do you want to just take that on notice and see if it's
Yes,
within your
yes.
capacity to respond to that? And if not, just advise us.
Yes.
The other thing, because this is my first day on this committee with you, so I've just got some pretty basic questions. I don't know if you may be able to help me or other members of the committee. With regard to civil penalties being imposed on the US for a company that is not complying with an order, is that clear in this document? The status of, the process about what would happen?
Senator, on the basis of the information that I've read, I can't answer that question off the top of my head. So again, we could take it on notice and get back to you.
It may be even a question that I need to ask the Secretariat to really get across.
I suspect that some of it was covered in that first hearing, and we did receive some additional material in writing after that.
Yeah, I had a look at that, but I couldn't kind of get an answer to that question.
Correct.
Nonetheless, it's on the record now, and that's probably my questions for today. Thank you, Chair.
Okay. Committee members? No. All right. Look, thank you both for your attendance here today. If you've been asked to provide any additional information, and I think there's been reference to a couple of things that you might be able to give to us, would you please ensure it's forwarded to the Secretary within 7 working days? As I said in my opening remarks, it's the witness's responsibility to meet this deadline in a timely manner. You will be sent a copy of the transcript of your evidence when it becomes available and have an opportunity to request corrections to transcription errors. But otherwise, thank you both for your submission and for your evidence here today.
Thank you for the opportunity.
I welcome Mr Henry Chen to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
My name is Henry Chen. I appear as a private citizen, though I'm a student at UNSW.
Thank you, Mr Chen. The committee doesn't require you to give evidence under oath today. I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence you give today will be recorded by Hansard and attracts parliamentary privilege. I invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. This appearance is essentially a follow-up on my submission to the Joint Standing Committee on Treaties in relation to the Cloud Act Treaty. It's essentially a review of the treaty from the perspective of international law that makes 3 points. First, that the treaty ought to be adopted because it clarifies the international law relating to the principle of sovereignty. Second, that the dispute resolution mechanisms in the treaty ought to be improved. And this essentially goes to the concern raised in the previous session that the tech company receiving an order needs to be the one to contest it and that Australia doesn't itself get any oversight over incoming orders. And the third point is about the use of the AAT as the other independent authority that can review orders in light of recent concerns about the independence of the AAT.
Well, thank you, Mr Chen. I'll invite you to explore a few of those things and then other people will jump in. So on the dispute resolution part of it, I mean, as you've observed, there's a domestic process that will occur in each case, possibly in the United States or in Australia, and it has to be in keeping with the relevant domestic legislation. So for us, that's the TIA, and then an order will be ticked off by some part of the AAT, depending on whether it's domestic law enforcement or an intelligence and security agency, and then it goes via the designated authority. The Australian designated authority make sure that it complies or that it has those things, and then it goes directly to a US provider. So the point you're making is that there's nothing on the US side of the fence that considers the appropriateness or the rightfulness of the order, other than the provider themselves, which is not usually thought of as having particular expertise when it comes to law enforcement or privacy or any of those kinds of things.
That's exactly right. So thinking about it from the perspective of Australian police, for example, sending a production order to a US tech company, the US government doesn't get a chance to review that order. And although there's a provision in Articles 511 and 512 for disallowance of orders, it's the tech company that needs to first flag that as an issue. And if, for example, Facebook receives an order that goes against US essential interests in some way that hasn't been picked up by the review processes, then the US government doesn't get a chance to review that. The greater concern, I think, for this committee is when those orders are coming from the US to Australian service providers, because that's where the orders could potentially target Australian citizens or implicate the death penalty, and it would be up to the Australian tech company to flag that as an issue. The government wouldn't be able to have oversight of that except in aggregate data reporting, and we don't know what level of granularity that will go into.
So clearly, I mean, the way the process was described to us, if a provider in either country gets a request that it's not quite sure about, it's the way it's supposed to work is that they first can protest to some degree back to the designated authority in the other country. But I believe I'm right in saying that if they're not satisfied with that, they can go to the designated authority in their own country. Do you think that provides some degree of capacity for the service provider to at least have advice from its own country designated authority?
Certainly it's a protection, and as you note, there are other protections through AAT review, for example. The overarching issue here, though, is that this is ultimately a treaty. It's an international law instrument that explicitly excludes any ability for the US and Australia to enforce the mechanisms of the treaty. It's essentially just putting in place a document that sets out the procedures that should be followed, but if those procedures are not followed, there isn't actually anything that can be done about that.
So do you have in mind how you think that ought to be structured? Are there other treaties that you've seen that provide a framework that you think would be preferable, particularly if they're in a relevant area, a law enforcement or a mutual legal assistance kind of a framework?
The key example, and it's a little bit dramatic, is the Australian Mutual Legal Assistance Treaty with Switzerland that allows disputes to be referred to the International Court of Justice. Now, it's unlikely that that would ever happen given the nature of the treaty, especially between Australia and the US. Nonetheless, it would be useful to have some sort of independent fact finder that could come in after the fact. For example, if the US had improperly targeted Australian citizens with a production order and simply issue a report stating what had happened and that was a breach of the treaty. Now, in practice, that might end up aligning with the suggestions made by the Council for Civil Liberties about a public interest monitor at the domestic level rather than international dispute resolution. But the key point is that there ought to be some kind of independent fact finder and not merely the remedy for a breach should not simply be that Australia terminates the treaty and walks away from this benefit of sending production orders to US tech companies.
Can I ask a question?
Yes, by all means.
So, first of all, Mr. Chen, where are you in your study sequence?
I'm in my final year. I'm finishing at the end of the year.
And what is the degree that you're undertaking?
Is law and international studies.
And I'm delighted that you're here as a citizen. I think this is fantastic to see citizens who are aware and come in. And I'm reminded of evidence given by Mr. Kenneth Seng from University of New South Wales, with regard to the decimation of the national broadband network, and everything he said was absolutely predictive of what happened and the consequences. So congratulations on your participation. Thank you very, very much. So my question really is just to clarify with you for my own thinking that you have articulated a fundamental design flaw in the structure of the way this treaty document has been advanced, and you would be, if you were to design it, you would have a gate on either side of this that would necessarily involve each jurisdiction in some supervision of an order. Is that the design flaw that you're describing? Because they're both absent from that until after the fact of the order.
I wouldn't quite go that far. Others might. Because I think the fact that there isn't a gate on the recipient side is a feature, not a flaw. And this goes to the rationale for the treaty, which is to enable a speedy resolution of international production orders.
Yep.
If they had to go through the US government, they would
And
take
in essence,
years.
you support this document. That's your first statement here.
Yes.
So what's the fix for the problem that you've described?
I think the fix is essentially we're coming to about three possibilities. One is the dispute resolution arbitration that I suggest in the submission. One is this public interest monitor suggestion raised by the Council for Civil Liberties. And one might simply be beefing up the annual reporting obligations in the treaty to provide granular information about the details of the orders that were made, so that after the fact, members or persons involved in the operation of the treaty can review whether any of the protections in the treaty, such as freedom of speech and political opinion, were breached.
So how does that final suggestion of your, three elements of design reshaping address the questions that were raised in the previous session by Senator Cox and Mr Wilson with regard to the time that it may take for a series of documents to be acquired to create the necessary burden of proof to advance a case that requires a legal resolution?
It should make no difference at all, because all of this review would be happening after the fact. So the police agency, for example, would still be able to send the request and get the response, but it would simply be a matter of perhaps 6 months or a year later trawling back through the records to find out what happened and figure out if there was a breach, announcing that fact and allowing decisions about the treaty to be made from then on.
So if you were to design an external, advance an external dispute resolution clause, what would it look like? Because I didn't... Did you attempt that?
No, I didn't.
Yeah. Do you want to take it on notice, Mr Chair?
I might have to take that one on notice.
I'd be interested in what you think such a clause might look like and how it would be given effect.
So the key example of arbitral tribunals in international law comes from the commercial context.
Yep.
And essentially there will be a dispute resolution clause that says that a certain number of arbitrators will be appointed at a certain seat, and that essentially something similar to a court process will take place. One party can make a claim. Now, I don't know whether that's appropriate for the law enforcement context, as was suggested. Again, the key point that I make in this area of the submission is that it doesn't seem to make sense to put in place a treaty with no teeth to it that can't ever be enforced. And that's a particular concern when we're dealing with the US, which does have a certain record of issues with legal compliance in overseas surveillance.
Thank you. Thanks, Chair.
Mr. Birrell.
Mr. Chair, could I just ask a clarifying question based on what Senator O'Neill said, and just so I understand where we are. So I'll just go through my understanding, and if we can make sure that's clear, that this is a treaty, so it goes both ways. The majority is going to be Australian law enforcement authorities talking to American providers, because most of the providers are American, but there will be some cases where there are Australian service providers where US authorities are able to make applications. The point about the dispute resolution that Senator O'Neill talks about is, are we worried that, or are you worried that there may not be a dispute because no one will ever, the only two organisations that will know that there's been a request and data given are the American Law Enforcement Agency and the Australian service provider?
That's exactly right.
So there could be no dispute because no one will ever know. And are you saying that there should be some other organisation that is made in Australia, an authority organisation, that is made aware that an application has been made and the data has been given, so that at a future date it could be reviewed? Does that clarify?
Like a log.
Yeah, does that clarify what we're talking about?
Yes, that is the second suggestion.
I'm not sure. I mean, to the extent that there will be sharing of information between the two designated authorities at an aggregate level, so that within a financial year or an annual year, you know, the Australian designated authority will advise the US that this many orders have gone through, and vice versa. I'm not sure that is not the case. I don't remember from the evidence we've received. We can have a look at that. I don't see any reason why both countries as parties to this agreement would have a problem with that sharing of aggregate information.
Yeah, the sharing of aggregate, I suppose, going to perhaps Mr. Chen, going to your issue is that the aggregate data doesn't say that the FBI requested information from Australian service provider X and Australian service provider X gave that information.
No.
Do the Australian authorities ever find out that happened?
Well, we haven't obviously.
Specifically?
The agreement's not in place, but yeah. I mean,
in the hypothetical scenario that's how it works. I suppose that's getting to the point of.
Yeah,
we'll
have to check the reporting requirements. There are obviously also domestic reporting requirements, and I think some of them will be matters on the public record. So it would be salient to know, I think, if there were 100 orders issued, and in relation to those 100 matters, only 2 convictions occurred, that would be a cause for concern. It's like a ratio between arrests and convictions. You know, if that happened to be, if you received that information in aggregate, you would be saying to your treaty partner, I don't think you guys are doing your due diligence as far as who's getting these orders for what purpose.
Yeah.
So,
And it'd be pretty rare for a law enforcement agency to go direct to a service provider. They would be law enforcement to law enforcement, is my understanding.
yeah, but that's what this provides obviously for law enforcement to get an order and just go and get the data.
This
Yeah.
was
Respectfully.
the timeline.
Yes.
Just respectfully
That's right.
through the chair, though.
Yes, sorry, that's right, Mr. Bird.
And maybe Mr. Chen might be able to provide some clarification on this, but my take on this would be that there would be a review conducted at the point in time which the overseas entity then initiates official charges or asks for an extradition of an offender to essentially conduct legal proceedings for a criminal offence. That would be when there is a review of the data that's been requested under the IPO, I think it is. Does that make sense now?
Well, except in most cases, like the majority of these cases are going to involve Australian domestic law enforcement seeking to make out a criminal prosecution against an Australian who's in Australia but whose data happens to be in the US.
But on the flip side, though, this is where I think that the issue starts to arise, is when we start talking about potential espionage or freedom of speech issues, where we might have an Australian national making certain statements or accessing certain data that might be in contravention to the United States wishes, and therefore they extradite make application for an IPO against that citizen through a provider that subsequently results in an extradition out of the country for prosecutions to take place in the States. That's where the big concern is the data request of Australian providers, not the reverse.
Well, it's true, but the agreement is limited to the US pursuing their citizens and us pursuing our citizens, and that's where the targeting provisions go to. So in fact, there's an obligation on each side to make sure that even where we are seeking information in relation to an Australian, we can't frame the request in a way that might put the privacy and data of an American at risk as a result, because perhaps the Australian is having a conversation with an American or something. Yeah, but I think the point that Mr. Chen makes is that all of those considerations essentially occur in first our country or alternatively the United States. They're not in any way supervised or visible to the law enforcement in the other country, and then they eventually ended up being put at the feet of a provider.
Exactly. So, Chair, you note that there are these targeting restrictions. In Article 4.2, it states that orders subject to the agreement shall not be used to infringe freedom of speech or disadvantage persons based on their race, sex, sexual orientation, religion, ethnic origin, or political opinions. Now, these are all very good substantive protections, but they rely on that agreement actually being enforced and being enforceable. Now, in theory, of course, it would be best if the US never even contemplated, if it was never physically possible for them to target an Australian citizen's data. But if they follow the agreement, then that won't happen. But if they do, then there is nothing that Australia can do about it, because we won't necessarily see it in the aggregate reporting at the end of the year, and there's no dispute resolution.
No, I mean, before the event, you're correct, but I guess you would think, and this goes to the piece about the way in which providers are educated. I mean, in reality, I suspect that the kinds of companies that will be on the receiving end of these orders are not in their hundreds and thousands. You know, they're a relatively small handful of large data collectors, and I'm fairly confident that they will understand that if they were to get a request, and the request was very poorly framed and seemed to be, in the case of an Australian provider, to cover and compromise data of Australian citizens, that would be that alarm bells would ring. I mean, that doesn't take a lot of expertise or esoteric knowledge. If the US law enforcement comes to a data provider here and says, oh, we want to access the data of 8 people, one of whom is a US citizen and the other 7 are Australian citizens, you would think that data provider would say, no, hang on a second. The US citizen, yes. The Australian citizens, no.
Essentially, it's a question of how much power we want to put in the hands of those organisations. Do we want leaders of tech companies making these ethical judgments about compliance with the treaty rather than the Australian government? And that's essentially a question for the committee.
Indeed. Let's just touch on the AAT, being mindful of the time. So in your view, I mean, the AAT or the Security Appeals Division of the AAT needs to be part of the process, and we have been provided in between times with some information of all of the considerations that they need to have in order to ascertain that it's a lawful request, and that includes considerations of privacy and proportionality and whether or not there are alternative means of getting the information that's sought, those kinds of things. But you're essentially making the argument that neither the AAT with respect to domestic law enforcement nor the Security Appeals Division of the AAT with respect to requests that come through ASIO is of a sufficient quality or elevated level of judicial screening.
Yes, that's right. So this was originally raised when the IPO bill was passed about 2 years ago by a number of submitters, and the conclusion in the end was that the AAT was good enough because as an other independent authority, it met the requirements of the US Cloud Act, and so it got us across the line to be able to negotiate this treaty. Now, since then, there have been two key developments. The first is that the US and the EU are negotiating a Cloud Act treaty, and EU law is more stringent about who authorises its production warrants, thus risking that we'll be left with a second-class system where the EU will require judicial authorisation, but we won't. The other thing that's happened in the past 2 years is that the Legal and Constitutional Affairs Committee in this Parliament of the Senate has recommended that the AAT be disassembled and reconstituted as a result of concerns about the independence of the appointments process. Now, in light of that, and in light of the seriousness of the international production orders and their effect on US and Australian sovereignty, I argue that the AAT should not be approving these orders and that a judge or a magistrate should.
Okay, yeah, I mean, it's like clearly the reference point, the starting point for us and for this agreement is that under the TIA regime as it is, it's the AAT that approves it domestically in any case. So that I guess is the starting point. But your other points are well made. I mean, it is interesting, obviously the conversation, which is part of, it's on the front page of the Australian newspaper today, is ostensibly in relation to the Anti-Corruption Commission. But yes, it is passing strange to have members of the former government questioning the composition of the AAT, whose composition.
It's because they know them well and they know they shouldn't have put them there.
They're entirely responsible. But and I think,
Mr. Chair.
Well, no, it's just an observation,
Sorry,
Mr. Burrell. I mean, but it's the Attorney General has made clear today that there's a process of looking at the AAT, and I'll just come back to the point you made before, Mr. Chen, and you probably know this because you're obviously very interested in it. But Mr. Warnes of the Attorney General's Department, in his evidence to this committee, did draw to our attention the fact that there's a larger electronic surveillance reform piece of work that's occurring at the moment that will be looking at some of the issues that you've raised and other submitters have raised. He noted there was a discussion paper that had been issued about 18 months ago, and it does include issues that go to public interest monitoring and oversight, compliance and these matters. So clearly this is going to be something that needs to can keep being looked at and keep being improved. And I suspect, I mean, there's no reason to believe, much as Senator O'Neill's talked about the review process, you would think that as those things are considered and those improvements are made, they will inevitably improve the way that this kind of agreement works. And this agreement itself is an improvement on the mutual legal assistance framework that we currently have to use. So you're welcome to comment on that if you're already aware of that.
I would comment only just to say that this argument was often made at the previous hearing that we wanted to align the Cloud Act treaty, the protections in the Cloud Act treaty with our domestic protections. Now, in principle, consistency is a good idea. The one reason I would caution against that is that in terms of domestic interception and production orders, Australia can, as a matter of international law, can do anything it likes within its territory, subject to the Constitution and so on. Going overseas, however, involves acts which, as I say in the submission, could potentially breach US sovereignty but for this treaty. And for that reason, production orders going overseas, I say, ought to be treated with greater circumspection and there should be greater protections in place. And the point about the AAT, for example, goes to that, even if it's not symmetrical with the domestic framework.
On a risk-reward ratio
Yes.
basis. Can I ask one further question?
Of course.
With the previous witnesses from the civil liberties, I asked them a question and they basically sort of separated themselves from a joint submitter with them around protest from the sector in terms of the cost imposed on them. Mr. Chen, do you have a view about how valid such a claim is with regard to, we do our business, you shouldn't impose this further cost on us? What's the arguments for and against, Mr. Chen?
I'm not familiar with the internal workings of the tech companies and these sort of resourcing considerations. The one point I would make is that the civil penalties threatened to be imposed by the Australian government if, for example, Facebook doesn't comply with an Australian production order are entirely consistent with the purpose of the treaty. And so we shouldn't worry about imposing too much of a burden in that respect, because the whole point of the treaty is to lift the US blocking statutes and enable Australia to impose those burdens and force those companies to provide the evidence following the domestic warrant procedure.
Thank you. Very helpful.
Yeah, and I'll just clarify the point I was making before, that the conversation that's happening at the moment is in relation to the National Anti-Corruption Commission and the way that information might be sought in relation to investigations that it might hold in future. And part of the question is around the AAT. The reality is that there could well be either law enforcement or foreign interference or other kind of security matters that were pursued by security agencies separate to that would occur through this agreement in future, and it could relate to parliamentarians. But this agreement, which was signed by the previous government, clearly contemplated that if that were to occur, that approval would happen through the AAT. But on that basis, I will thank you, Mr. Chen, for your attendance here today. If you've been asked to provide any additional information, would you please forward it to the Secretary within 7 working days? As stated in my opening remarks, it's the responsibility of witnesses to meet this deadline in a timely manner. You will be sent a copy of the transcript of your evidence when it becomes available, and will have an opportunity to request corrections to transcription errors. But as Senator O'Neill said, these processes are really only made effective and high quality by the time taken by people to be part of them, make submissions and appear before us. And it's always heartening when private citizens take time from all of the other things that they're doing to give us the benefit of their thoughts and their work. So thanks for your submission and for being here today.
Enjoy your final little bit of study before you go out and start earning a lot of money, I expect.
Thank you.
Thank you.
Yeah. On that basis, committee members, I declare this public hearing closed.